In observance of the Thanksgiving Day holidays, all county offices will be closed on Thursday, November the 23rd, and Friday, November the 24th. All offices will reopen on Monday, November the 27th.
Commissioner Andrew Haggerty would like to invite you to his weekly breakfast meeting that takes place every Wednesday at 7:30 a.m. at Danny's Diner, located at 4690 Trans Mountain Road. Every week he has a different speaker who will be discussing topics of interest for the community. So if you live in the Northeast, West Side, or anywhere else in the county, come and join us for the breakfast meeting.
You can now watch Commissioners Court meetings on YouTube. Go to youtube.com and search for El Paso County Commissioners or El Paso County, Texas. Subscribe to our channels to see our latest videos.
Don't wait in line, pay online. Visit the Financial Recovery Division website at http://www.epcounty.com/budget/financialrecovery.htm to make your payments online or find out more about our kiosk locations. We now accept payments on misdemeanor, felony, and justice of the peace cases. Did you know the County of El Paso's Purchasing Department is responsible for ensuring that all items and services needed by various county departments are purchased in the manner required by the state of Texas? Whether through formal sealed bids or smaller dollar quotations, the county purchasing team is dedicated to finding the best contracting return on your taxpayer dollars. Additionally, the Purchasing Department is responsible for the tracking of inventory within the county and properly disposing surplus to public auctions. For questions about how to become a vendor and compete for county contracts, or to learn more about public auctions, please contact us at telephone number 915-546-2048.
Did you know that you can save money on the cost of your medications? And doing so is easy. In 2015, the County of El Paso launched the prescription discount card program from coast to coast. The cards are available to all El Paso County residents free of charge and everyone qualifies. You can pick up a card at any county office location, Walgreens, Walmart, CVS, or Target pharmacies, or simply print the card at www.coastrx.com. Happy savings!
The 346th District Court Judge Angie Juarez Barril started the El Paso Veterans Treatment Court program in 2012 for veterans and active service members that have been arrested and charged with a felony or misdemeanor criminal offense. To be considered for the specialty court, the statutory criteria includes be a veteran or current member of the United States Armed Forces, including a member of the Reserves, National Guard, or State Guard, and suffer from a brain injury, mental illness, or mental disorder, including PTSD, or be a victim of military sexual trauma, all occurring or resulting from military service. Call Sylvia Serna, Veterans Program Director, at 915-546-2119, or email her at sserna@epcounty.com for any information.
Did you know that the County of El Paso's fixed asset control and inventory disposal is handled through the purchasing department? Throughout the course of each business year, the county holds live public auctions to dispose of aged equipment, vehicles, furniture, and other items that are no longer needed. To find out about upcoming auctions or to learn more about the county's inventory disposal process, contact the purchasing department at telephone number 915-546-2048.
Executive session, that's why
Right.
we're
Okay, good morning. Today is.
Wait, just, no, it's not, look at the screen.
It's not on
There,
the
now we're
screen.
good.
Okay, yeah, usually that's wait till it's on the screen. Good morning. Today is Thursday, November 16th, 2017. Commissioners Court is meeting in special session. Regular agenda, item 2.
Actually, I'm so sorry, Jen.
Thank you.
Can we go ahead and postpone item 2 for just a second? I'd like Commissioner Bettis to be here for that item.
And he's
I
gonna
believe
run.
he's gonna delete that item, but I'd rather him go ahead and make that motion. So we could pull up item 6 first, because I believe we have guests here to speak on that item. I don't wanna keep them here throughout the rest of our agenda.
Thank you, Judge. Item 6. Receive a presentation and discuss options regarding a proposed county invocation policy.
Commissioner, morning, Betsy.
Good morning. We brought this item back based on recent changes that we've made. May I have the mouse? We've received additional input on the policy, so we've brought back the draft. I think the court has seen it for the court consideration if you'd like to adopt the invocation policy. Some of the changes are to make it more clear that it's a non-denominational invocation. It is open to basically anyone to present. The purpose of it being for the Commissioners Court, not the public.
So were those the only major changes in making it more of a public? I'm trying to, I went through what was in the backup and I just didn't know where this.
I believe, and correct me if I'm wrong, Ramon's here, but I thought the intent was to open it up to anyone.
That's why I was confused about that, because that says it will be done by a pastor or minister, and below that it says it's open to anyone.
Yeah.
I think we missed that. I think we missed that. It's to be opened up to anyone.
Okay.
And that's my apologies. I missed that. And then that it could, depending on who wants to provide it, what type of message it would be. It can, here's where we say it again. It may be delivered by any adult citizen. So we just failed to take that out there. So that would be a change. It can be delivered by any adult citizen. We don't exclude anyone on the basis of religion. Any faith or any belief could deliver it.
And would this be as a part of our regular, a part of the agenda, or would this take place prior to the start of the meeting?
It would actually take place after the open of the meeting.
And what would be the process to allow for individuals from the community to, we're gonna have an online application that they can fill out?
They would sign up to, we can make it online, but right now we plan to have people contact us if they'd like to be added to the list. We would then create a rotation for anyone who wanted to be on the list. We wouldn't repeat individuals on the list until we had gone through the entire list to provide for fairness. And if there was somebody who, if for some reason someone on the list couldn't make it, we'd go to the next person on the list. Or if they don't show up the morning of court, we would ask if there were any volunteers who'd like to do the message that morning. And again, we continue to ask that it not be disparaging of any faith or belief, not be trying to advance a specific faith or belief, and whether or not no one would be required to participate if this is more for the governing body.
And one of the things that I was thinking about, Betsy, when we communicate, when we call someone, okay, you're coming up next, are you going to be able to make it? And they tell us, no, I personally will not be able to make it. I'm sending X. Is that allowable?
Yes, sir.
It is? Okay. Okay, thank you.
On the second page, top of that page, it starts off with, while the day's prayer will not be subject to prior approval, and then it goes on to the day's invocations. I don't know if we could just streamline the.
We should probably say that just because we're not making, it can be a message. We should probably say, well, the day's message will not be subject to prior approval. It should follow these guidelines, or we could say the day's invocation, whatever their preference.
Commissioner, did you have any other questions? I mean, it seems like this still needs to be edited a little bit.
I think if what you want is prayer, is being watered down to the point it's not a prayer. If you want it to be, we're giving someone a microphone and giving them the opportunity to say whatever they want, which could be disparaging, which could completely go against everything that we're trying to do. I think we're opening ourselves up for, if nothing else, to take away from what we're trying to do. And what we're trying to do is government business. And I understand, I go to church every Sunday, I pray every Sunday. I don't need the government's help tell me when and where to pray. My problem I've got with this is it's going to become, this is what the media is talking about and not the good we're doing and not what we're supposed to be doing. And it's just another thing that's going to distract from stuff. I still remember from last year, one of the best things we did that we've been working on for a very long time with roads. Not a single person was in the room because we were talking about the historical commission outside. That's what we're going to do with this, and it's going to become a media frenzy when it doesn't need to be. If you want to pray, pray. If you don't, don't. I don't need the government's help telling me to pray. For people who want prayer, we're watering it down to where it's not prayer. For the people who don't want prayer, it's still there and it's still going to make them mad. You're still going to have groups that kind of come in and want to speak. That's going to upset other groups. This is just going to create media circus that we don't need, in my opinion.
Commissioner.
When I first started here in 2013, we had the invocation every Monday. Mr. Davis was doing it, and we never had any problems. But I do have more things to say. I don't want to hold up our guests. But if you go back to where it says today's prayer, I agree. I think we should change that to the invocation, not the message, invocation. In respecting our guests' time, it's up to you, Judge, but
We do have two members of the public signed up to speak, and I believe we'll start off with Mr. David Marcus. Thanks, Mr. Marcus.
And you will be allowed 3 minutes, sir.
Thank you.
Thank you for being here.
Thank you, Judge and Commissioners. Thank you very much for having us today. I'm here as a representative of Join Us for Justice, the El Paso chapter of Americans United for Separation of Church and State. Our membership includes citizens of El Paso interested in equal rights under the law. They include theists and non-theists, Christians, Jews, Catholics, atheists, agnostics, members of the gay and lesbian community, and many others who agree with the mission statement that focuses on equal rights under the law through separation of church and state. When considering this policy and invocations, I know you've all considered all the impacts that will happen from this decision, but I'd also like you to consider that this is not a house of worship. In a house of worship, people gather who, for the most part, agree on a certain belief system and share a common prayer. And they usually work together in whatever way they see as feasible to better the lives around them and their community. This is a government legislative chamber. There are people in this audience today and in any given week who represent a myriad of different faiths and many who believe or don't believe in any organized religion. They are all our fellow citizens, and they are coming here to exercise their First Amendment right to petition their government on an issue that's important to them. Many who are not members of whichever religious group is giving that week's invocation will at best feel uncomfortable sitting through something they don't necessarily believe in, and at worst may feel compelled to make their stand public by leaving the chamber during the prayer. A stand that quietly creates division among those in the audience, and for those who are there to transact business with you, for those that are there to transact business with you, a subtle feeling that their argument may not be heard by you in the same manner as those citizens who chose to remain for the prayer. You aren't required to have an invocation, and we certainly hope that you would choose not to. But we also realize that if you choose to have invocations, that they must follow the decision as expressed in the 2014 Supreme Court decision, Greece versus Galloway. Some of the most important points that came out of that decision are the following. Messages can be given by anyone. You've mentioned that. Any member of the public can give an invocation, those that represent any religious group, and those that self-identify as not belonging to any faith. That includes atheists, agnostics, and any minority faiths, many of which you may disagree with, as well as those pastors who are members of faiths that have a long history of denigrating minority groups. They are all eligible to give invocations. Second, invocations are not to be directed to the audience, but rather to the legislatures, you. Therefore, you cannot ask the audience to rise, bow their heads, or do anything that requires them to take part in that invocation. Whoever is giving an invocation cannot use that time to proselytize or disparage religious minorities, non-believers, or any other minority group. And of course, you must separate the prayers or invocations from your policy making. At best, that something should be done before your meeting begins. If you're intent on passing a policy for invocations, please let us help to define that policy so that it falls within the framework of Greece versus Galloway and doesn't create issues for you in the future. The policy you are considering this morning has a number of issues that conflict with each other and some that directly do not follow that decision. Thank you very much. The other speaker today isn't going to make it because he thought it was going to be later in the agenda.
I think there's one other person, Mr. Marcus and Judge, there's one other person who just signed up. Thank you.
Mr. Marcus, you mentioned that the current policy conflicts with, and I'm assuming you've seen this revised version, there are conflicts with decisions that have been handed down in the judicial system?
Well, some of the stuff Ms. Keller addressed. The first paragraph mentions that it's got to be a pastor or somebody from a religious ordained minister of some sort. There are a number of other things that might be improved on to better match up with what the Supreme Court decision said. You mentioned in this that it's not for the public, but for lawmakers themselves. But the Supreme Court went beyond that, and they actually point out what you should not do. And I think if it's a policy that's going to define this for the future, and trust me, I know many of you, Carlos, I've known for decades. You guys aren't going to do anything wrong. But nobody knows who's going to be sitting in these seats 10 years from now. And they're going to be using this policy to define what they do. And what you want to do is define it as close as possible with as many details as possible to prevent somebody from using it to denigrate anyone else. And so I would even point out in there that you can't ask the audience to rise, you can't ask them to bow their heads. You can't mention that they should leave if they don't agree with it. I think I may have sent a letter to Ms. Keller that addressed some of those issues. So she's got most of the details if you want to see that.
I do have one more question. This is for the county attorney. With there being a thing of what we can and can't do, we give the microphone to someone who we've given the authority to give the invocation. They go up and do a rant against a group of people, a rant against a group of religion. Is there anything that can happen? Can someone sue us? Is there anything that can be done from the public to say that you've affected my First Amendment rights? Are we putting ourselves in jeopardy of a lawsuit from somebody?
I think you're assuming, so say for example, somebody does go up to the podium and they go into the message or the invocation before the court, and then they go into some of these issues. And so I'm assuming that how it would be raised or what the scenario would be, for example, is if it does go into some disparaging comments regarding a specific race or gender or whatever. I guess at that point, what I'm envisioning would maybe be the commissioner's court or somebody from the court saying, stop, this is offensive, you can't do this, you need to leave, or stop what you're saying and cut them off at that point. I don't believe that there is any legal prohibition in doing that because it is going into the disparaging nature of making those remarks. And to the extent that that person is participating under the invocation policy as an invited speaker, somebody that had is part of the rotation, if you will, of the county's message list, if you will, the county commissioner's court could also prohibit them from returning back.
But
right. And
my question is, someone else in the audience feels they've been insulted.
Right.
Do they have what are the chances of us getting a lawsuit or something like that?
I don't necessarily think it's, I think with any topic that the commissioner's court undertakes, whether it be a message given by somebody else, they certainly can make the complaint that they're offended by the message. But really what the issue could become, for example, and what was considered in the Greece decision was whether or not there is this pattern or practice of endorsement by the government body. For example, if they are saying that I am offended because each week it is a message only reflective of the Christian faith, or somebody's going up there and saying Jesus or God in the message, and they point out that this is happening week after week and it is some sort of endorsement from the county, and I think that could potentially become an issue for the county in the future. But just to say that I'm offended because a certain group had come up, I mean, it could be anybody from the court as well. As Mr. Marcus had indicated, there are going to be, if this is opened up to the public, there may be the issue that you might not agree, for example, with somebody from the Wiccan faith coming up to say certain topics. So obviously there may be the chance or the issue that somebody from the public, not to mention the commissioner's court, may be offended by that. But that is part of the policy because you have to open that up to everybody. You can't say, only this certain group's allowed, only this certain faith is allowed, recognized or unrecognized faith. So that's where it really becomes the issue, though, again, is what I want to emphasize. If there is a pattern or practice of the court or implication that they're endorsing a certain particular recognized religion, whatever that may be. And so that's why in the policy, you're saying that you open it up to the public. And that's why you're saying that you're going to, that the county administration is going to open this up and make sure that it's not just individuals from a certain faith that are invited to participate, but any member of the public, whether part of a recognized religion or not. So.
And along those lines, we have a very diverse community, obviously. So if we were to have only members of the Christian faith say, we want to show up and provide this invocation, but it's been open to the public, but that's the only response that we're getting, could we be sued because that is the only response that we're getting from the direct call to the public?
I think that there is a risk in that, but what is looked at holistically is what efforts, if any, that the county commissioner's court or county administration has made to make this process inclusive of everybody. Again, regardless of whether they are part of a recognized religion, regardless if you agree or disagree with that practice. But again, that is what I would argue is an issue that was left open by the Supreme Court case. Is what efforts, if any, did the court do to make this an inclusive process? I mean, I think it's a slippery slope in which I think it could easily be that, you know, there might be an active group or maybe a more recognized group, if you will, in this community that might make efforts more so than others to be part of that process. But as long as you made that process open to everyone, and as long as there was some effort, I think, made by the Commissioner's Court to making it inclusive and maybe perhaps reaching out to other groups, recognized or not recognized, that might not pose as much of as an issue. But it does, it's still an issue.
Could I mention one more thing along those lines? Our organization was founded about 7 years ago. That came out of the dust down the road at City Council. All of you are aware that there are groups here in El Paso that use their faith to denigrate other people. And we realized at the time there was nobody here to teach the First Amendment or what the Establishment Clause was saying. But we understand the consequences of an invocation policy, and we understand the need to open it to everybody. And so if those same people that created us 7 years ago were to come to you and say they want to do an invocation, we would fight for their right to do that, as much as we disagree with their message. And I think that's the important part of this. Anybody can give an invocation. Thank you.
Questions for Mr. Marcus? I've got two other individuals who have signed up. Ms. Pam Ferroni and Mr. Sam Ferroni. If you want to come up individually or... Good morning.
Good morning.
Good morning.
My name is Sam Ferroni, and I have been serving the city of El Paso as a chaplain for 25 years, primarily with the PD, the police department, but also other agencies and entities in our community. I have provided invocations for many events and ceremonies and dedications and grand openings, including providing invocations for city council for, I believe, about 13 years now. In the way that the city council handles this is from the list of participants, the office of the city clerk provides a monthly schedule and communicates that to the participants. And then they show up and do the invocation on their particular assigned day. The invocations are not a message, it's an invocation. It's not to proselytize, but if anything, it is to bless. It is non-denominational and ecumenical, and if anything, to promote the positive principles of service, leadership, consideration, unity, integrity, and not with a message, but to promote those principles in an invocation. And I heard just a moment ago a comment regarding what if somebody feels threatened or feels insulted. And it's been a long time since I've been in a commissioner's meeting, commissioner's court, but have been in many, many city council meetings. And speakers, not those who provide invocation, but the speakers. And my question is, do you ever have speakers that rant against a group or an issue? And as a result of that, do people leave the court? At any rate, I believe that providing invocations is a positive thing, and it does promote peace and consideration in all deliberation and discussion and decisions. And calling upon that, the Almighty, the higher power, so to speak, if you please, to provide wisdom and guidance in discussion and decision-making that is above all. So thank you very much. Any questions for the commissioners?
Judge, commissioners, Chaplain Ferroni is, as he mentioned, he's a police chaplain, been a police chaplain for many, many years. And I think I've said this before, that before the chaplain's program, while I was a patrol officer for the city, in notifications that we've had to make, and if you go back in the many, many years that I was there, before the program started, you'd have to go to the home 3 o'clock, 2 o'clock in the morning, and tell the parents that their son or daughter's not coming home, their dad or mom's not coming home, or a brother, sister. And that's probably one of the hardest moments in a law enforcement person's life, job, to just tell them that and leave. When the chaplain's program came up, we were able to turn the family over to the chaplain, and it made a huge difference. What's my point? There were probably, that I witnessed, maybe hundreds of moments where there, for the most part, there were Christian households. Many times there were not. They ranged, it was the whole gamut of beliefs, religions. And not once did somebody tell me, no, I'd rather not have that help, or I'm offended, I don't want that person here. So it made a world of difference. And I, for one, I agree with you, Commissioner. I go to church, but the church stays in me 24 hours a day, whether I'm here, whether I'm in church itself. And the way I see things is, the reason that I am here is to help other human beings. And when I hear an invocation, it always reminds me of our purpose. But thank you for sharing your thoughts with us, Chaplain.
You're very welcome.
Thank you for being here. Ms. Ferroni, did you want to speak as well?
Yes.
Good morning.
Good morning. I really appreciate this opportunity. Thank you very much. I made up a little packet for Judge and for each one of the commissioners, and this is for Betsy.
Thank you,
Okay.
Mrs. Ferroni.
I have given a lot of thought to why there should be an invocation at the opening of Commissioner's Court, and I'd like to give you a little bit of background and my thoughts on this. In the United States, there has been a long history and tradition of prayer before legislative sessions going back over 200 years to the nation's founding. Opening prayers lend gravity to public proceedings. Tradition of opening with a prayer was established by the Continental Congress 2 years before the Declaration of Independence. The fundamental act of our founding, the Declaration of Independence, recognizes Creator God as the source of rights. You may be familiar with some of these phrases. Endowed by their Creator, appealing to the Supreme Judge of the world with a firm reliance on the protection of divine providence, or in the year of our Lord. The Constitution we subsequently ratified was based on God's model of civil government as set forth in the Bible. God's model comes from Isaiah 33:22. For the Lord is our judge, the Lord is our lawgiver, the Lord is our king. The civil model was based on God's model. The three branches of the federal government are judicial, legislative, and executive. John Adams made this statement: the Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other. Clarence Mannion, former dean of Notre Dame Law School, said, look closely at these self-evident truths, these imperishable articles of faith, American faith upon which our government is firmly based. First and foremost is the existence of God. Next comes the truth that all men are equal in the sight of God. Third is the fact of God's great gift of unalienable rights to every person on earth. Then follows the true and single purpose of all American government, namely to preserve and protect these God-made rights of God-made man. The Mayflower Compact was written 397 years ago, November 11, 1620. It opens, in the name of God, amen, having undertaken for the glory of God in the advancement of the Christian faith and the honor of our king and country, a voyage to plant the colony in the northern parts of Virginia. Brett Harvey and David Cortman are representatives of Alliance Defending Freedom, an alliance-building nonprofit legal organization that advocates for the right of people to freely live out their faith. They are the legal team that successfully defended the town of Greece, New York, before the Supreme Court that you have discussed so much this morning. This is an excerpt of a letter that they have written, and the commissioners all, I believe, or I know Betsy has a copy of that letter. In recent years, the historical and cherished American tradition of opening civil meetings with prayer has come under attack. Activist groups have filed multiple lawsuits making the extraordinary demand that public invocations be censored or silenced. But on May 5th, 2014, the United States Supreme Court clearly held that opening public meetings with prayer is constitutional. We write to update elected officials and concerned citizens about the Supreme Court decision that protects public prayer and the right of prayer givers to determine how they pray. It is both lawful and wise for public officials to respect and cherish our religious heritage and to invoke God's protection and guidance over their public work and our nation. There is simply no question that a public deliberative body may open its meetings with an invocation. Public prayer has been an essential part of our heritage. May I just finish this? I have just a little bit more.
Go ahead.
Thank you very, very much. Public prayer has been an essential part of our heritage since before this nation's founding, and our Constitution has always protected this activity. The Supreme Court has, for the second time now, declared that opening prayers do not run afoul of the First Amendment's Establishment Clause. In Marsh v. Chambers, Chief Justice Berger concluded, the opening of sessions of legislative and other deliberative public bodies with prayer is deeply embedded in the history and tradition of this country. From colonial times through the founding of the Republic and ever since, the practice of legislative prayer has coexisted with the principles of disestablishment and religious freedom. In Lynch v. Donnelly, Justice O'Connor and the Supreme Court affirmed that history is replete with official references to the value and invocation of divine guidance in deliberations and pronouncement of the Founding Fathers and contemporary leaders. It is the hope of the Alliance Defending Freedom that the information they provide will be helpful in explaining the reasons why governmental bodies can and should continue the American tradition of opening their public deliberations with invocations. They also encourage each deliberative body to codify its invocation practices with a constitutionally sound written policy. In fact, they are willing to assist in the writing of those policies pro bono and also offer pro bono assistance if that policy is legally challenged. In closing, William Penn, the founder of Pennsylvania, urged the union of all of the colonies, which subsequently became the United States of America. That same William Penn, in his first legislative act called the Great Law of Pennsylvania, wrote, whereas the glory of Almighty God and the good of mankind is the reason and end of government, and therefore government itself is a venerable ordinance of God. Make and establish such laws as shall best preserve true Christian and civil liberty, whereby God may have his due.
If you could just start to
1854.
wrap up, I'm so sorry.
Okay, just this last paragraph,
Sure.
yeah? I'm so sorry. In my, I'm just going a little bit slower than I thought I would. In 1854, the United States Congress declared, in this age there can be no substitute for Christianity. That was the religion of the founders of the Republic, and they expected it to remain the religion of their descendants. Whether anyone likes it or not, the United States of America was founded on Christian principles. We are a Christian nation, and our government is under God. In his famous farewell address on September 19, 1976, President Washington, who presided over both the formation of the Constitution and the Bill of Rights, famously admonished, of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. In vain would that man claim the tribute of patriotism who should labor to subvert these great pillars of human happiness, these firmest of props of the duties of men and citizens. The mere politician, equally with the pious man, ought to respect and cherish them. A volume could not trace all their connections with private and public felicity. I close with these words of President George Washington. It is the duty of all nations to acknowledge the providence of Almighty God, to obey his will, to be grateful for his benefits, and to humbly implore his protection and favor. I understand that a lot of things have changed in this country, and I just want to tell you all one thing, and I'm trusting that you will be led, you will know exactly how to create this policy, but I want to tell you that people of faith, people who call themselves Christians, have not always reacted right in ways, we have not always represented the world right. And for that, I am deeply, deeply sorry. And I wish it were not so. But it doesn't change who he is. It just means that we're human and we make mistakes. But I thank you all for the work that you are doing, and I really, really trust that you will be able to come up with a policy that will be a blessing to our community and will protect these freedoms. Thank you.
Thank you. Thank you for being here this morning. We do have another member of the public who had signed up to speak, Mr. Rivera. Cesar Rivera, if you'd like to speak. Thank you for being here. Good morning.
Good morning. Commissioners, Judge, thank you for having us. Just listening to the last member of the public participating.
If you could actually state your name and if you're with the organization.
I'm sorry, I wasn't familiar with the procedure. My name is Cesar Rivera, and I'm a member of Join Us for Justice, the local chapter of Americans United for Separation of Church and State. One of the things that I wanted to convey here is that we are in no way trying to convey the claim that an invocation would be a violation of the Establishment Clause. The Supreme Court has already decided that it is not. What we're trying to convey here is that to give better effect to the spirit of the Establishment Clause, it would be better to maintain the status quo and not to adopt an invocation policy to begin with. If the invocation policy becomes adopted, then what we want is that it actually goes by the guidelines already provided by Town of Greece in a couple of years ago. A couple of additional thoughts that I wanted to share with you are the following. There is no established religion. The original religion of the founders was not a single one particular unified theological framework. It was actually a variety of Christian positions, including some atheistic ones, some agnostic ones, and overall, there was no particular religion that was shared by every single founding father, and there is historiography to back this up. So the claim that was made just before I got here is actually historically inaccurate. However, it doesn't bear to what we're trying to do here. And the member of the public that just spoke said something about how Christians have not always acted with dignity or with respect to others. And I'm here to give you a couple of examples of how that has happened and continues to happen even after Town of Greece. Hindus, Muslims, atheists, non-Christians that have prepared an invocation and have delivered them in Congress in a variety of legislative bodies around the nation have actually been disparaged, have actually been disrespected. A couple of situations have occurred in Florida and in Arizona, some of which we already shared with some of you, where an atheist or an agnostic or a non-religious person stands up, gives an invocation, and somebody stands up and says, you know what, that wasn't an invocation to my God, therefore we have to do it again because it didn't work. okay? Because somehow God is going to remove his blessings if we don't mention his God. That kind of a theological understanding of the Establishment Clause is actually at odds with the Establishment Clause. One of the things the Establishment Clause is supposed to do is prevent the government from making any theological pronouncements. And it is true that throughout history, not every single decision has been in line with the original spirit of the Establishment Clause. But I'm here also to remind you that what has happened in the United States didn't end and didn't become frozen in history at the moment of the founding. The Establishment Clause has become integrated into the 14th Amendment by the due clause. It means that local, state legislative bodies also have to respect it. And that means that nobody can come up with some kind of governmental policy or decision that conveys the endorsement of one religion over another religion or religion over non-religion. Our understanding is the following. The public shows up to your meetings. They have a variety of disagreements on business. That is the business of the county to deal with. We would like for you not to add another layer of disagreement and division about a topic, about an issue that has nothing to do with the business of the county. To wrap it up, we agree that it would not be a violation of the Establishment Clause if you have an invocation, but if you do, make sure it follows the Establishment Clause jurisprudence established by the Supreme Court in town of Crease, and that you open it up to everybody. The only problem if you do that is that you're opening yourselves up to people who are willing to disparage, as they have done, members of other religions and people who don't have a particular religion, and sometimes also people that minorities, sexual or otherwise, that have been historically disparaged and discriminated against by religious people. Not all, but some. Thank you, Commissioners.
Questions? We appreciate all those from the public being here so early on a Thursday to address the Commissioners Court. I don't know if you have any other comments, Betsy, on this item?
Yes, sir.
It seems like, Commissioner?
No, I think this will be, I think it was set up for discussion or action today. Is that correct?
Correct.
Yeah. And it'll be reposted on a future Monday for a vote.
Okay. It does seem like, regardless of how the Commissioners Court decides to vote, that what is being presented needs to be altered, and it looks like that's already kind of being done. Betsy.
Yes, sir.
And so my question is, there have been mentioned by speakers today that this may not be in line with former legal decisions, mainly that it's not open to the public, to everyone, and it seems like that has been done. From what I'm reading in the current policy, is there any other items that have been decided that we are not including in order to ensure that the county would be protected should we pass an invocation policy?
Right, I had the opportunity, Christina Sanchez, Assistant County Attorney, had the opportunity to look at some of the comments that were submitted by Mr. Marcus in terms of the policy. And as the policy is now, there is no, in my opinion, it's not a violation of any particular law. It follows the premise of the Supreme Court decision. I believe that some of the points that were made in that by Mr. Marcus were to be more in line with what the Supreme Court decision said. I looked at it, I didn't have any particular, it's up to whether the county, again, it's a policy decision if you want to call it invocation, I believe, or the message, but it should be consistent throughout. However, you do refer to it as, you refer to it as at one point the invocation's message. So having consistency there, we already addressed the issue regarding that this will be open up to all members of the public and not just certain ordained or recognized ministers or members of or chaplains or clergymen from law enforcement offices. And also, it's just to make clear, and I think it's in here from my recollection, but to make clear in the policy that it is opened up to everybody in the public if that's the route or the direction that the Commissioner's Court wants to go, and that is in line with the Supreme Court decision. There was reference, I believe, earlier in this conversation saying that you can't make the members of the public stand to do that. There's nothing in the policy here that says that members of the public have to stand for the invocation, but it might be the case that if this happens or occurs right after the Pledge of Allegiance, you know, individual members of the public are standing, but I think it should be made clear in the policy that rather than it's a standing issue or not, that the members of the public do not have to participate in this. Again, if this is the direction that the Commissioners Court wants to take in actually adopting a policy. So those were the matters that were reviewed and discussed. Thank you.
Commissioners, any other questions? Otherwise, we'll go ahead and.
I don't have any questions, but I just want to kind of make my opinion known at this point after listening to the public comment and thinking about this quite a bit. You know, I'm Catholic myself, and I believe in the power of prayer, and I find comfort in prayer, but I also have concerns with us putting forth a policy such as this, because I also believe in the separation of church and state, and you know we've been very strong Commissioners Court when it comes to anti-discrimination and not being inclusive, and I think this, you know, could lead to something that is not of that track. You know, I think that if we adopt an invocation policy and if we end up limiting, you know, who offers it, it would become exclusive of people's beliefs and values. And we heard from our lawyer that I mean, we could be open to lawsuits possibly if we adopt an exclusive policy. You know, I know that the Supreme Court ruled that we can have ceremonial prayers and that we can do this, but there are limits that are imposed by the First Amendment. You know, if we end up doing it, you know, we need to allow anybody to come up and pray or whatever they want to call it. I mean, you know, there's I believe a study out there that talks about 40% of the residents here in El Paso may not even identify or affiliate with any religion. That's quite a large amount, in my opinion, and I can definitely see members of the community it being against something like this. And we have to keep those people in mind when we make this decision, I think. You know, we don't. In my understanding of the invocation is for, I guess, the members of the court. It's not for the. You know, you know, we can't ask the residents that are attending the meetings to join in the prayer. And you know, I believe that it's something that, I mean, if each of us feels like we need to pray or ask a blessing on the meeting, then we do that individually. And you know, I just don't feel that you know, because to tell you the truth, I mean, this definitely seems, you know, in the language it talks about an ordained pastor or minister. It looks like we could get rid of that, but you know, listening to some of the public speakers, you know, we hear the language bless, non-denominational, ecumenical, higher power, almighty. There are people that don't believe in those types of things, and we are going to be exclusive of those groups of people if we, you know, I mean, because this sounds very very Christian oriented, and there are people that are agnostic or atheist, or there are people that aren't Christian in this community, and it seems to me that something like this would be exclusive of all of those groups. If you're not Christian, then you're not taken into account. And I don't think that we need to send that message to the people in the community. Also, if people are not in agreement or not want to be with, be around when this, if this is part of our public meeting, it's not inclusive to ask people to leave the room. People may have to leave the room because it's something that they don't believe in. And I don't think as part of a public meeting, a governmental public meeting, we should be forcing people to make that decision. So that's kind of where I'm coming from. I think that we have our meetings and we run the meetings quite well, and things are fine the way they are. I think that if each of us, if you want to have a prayer session before the meeting, then those of us who want to participate in that, you can do that. But I just don't think that that we need to send a message that we may be sending. And so, I'm at this point in time definitely leaning towards voting against instituting any type of policy like this. Thank you.
I do have something to say. And in listening to what you said, Commissioner Stout, there's really no disagreement with what you're saying. But I do feel that we clean up our policy where it in fact is almost, we're almost there, where it's really open to everyone, We are going over and above that by contacting the people that are next in the, let's say, in the wheel to be able to come and speak or not speak, whatever they wish to do. And if they do not wish to come, well, they don't wish to come. I don't see anywhere in the policy where we're making it a Christian directed invocation. If others do not wish to come, well, they don't wish to come. I know that in the city, as the chaplain mentioned, you've been doing it for 13 years. And I know there's been a couple of issues, but I don't think they resulted in lawsuits. And we've had some comments made in public comment. And public comment we don't have to have, but we do. We have it, and it's been, in some cases, very insulting to some members of Commissioners Court, some members of our community, but we allow them to finish. So I think by having this is, to me, as I said earlier, a reminder to me that my purpose on this court is to help other human beings. So that's just my thoughts on it. I really appreciate everyone that's here today to lend your voice to make us prepare a much stronger policy and move forward. Thank you.
Well, the item isn't posted for action today, so Commissioner Bettis, did you want to come here?
As I mentioned last time, I attended a Catholic university which was fortunately very open to other faiths, and it was, again, as I mentioned, it was the first university to hire a rabbi as part of the campus ministry, to hire a Muslim imam as part of the campus ministry, and they recently hired a person of the Hindu faith to be part of the Catholic ministry. And it created, even though it was a Catholic university, it created such a sense of inclusiveness, and it has really helped shape, my thoughts today. And when I look at an invocation policy, it's I hear various arguments. I mean, I hear one that El Paso is overwhelmingly Catholic, and therefore it's going to be geared towards one particular, or overwhelmingly Christian. It's going to be geared towards one particular faith. And I hear another that there's a large segment of our population that doesn't affiliate with a particular organization. I mean, if either one of those are true, to me, an invocation policy creates an opportunity to, unfortunately, when you look at all the divisiveness in our country, a lot of that stems from us not fully taking the time to know one another and to get to know people of different backgrounds, of different faiths, or people of no faith. You know, we view, and unfortunately, there are people in society who, if you don't think the way that they do, or if you don't have the same belief system that they do, you know, you're the enemy, or we're going to sort of demonize you, or you know, and it's truly unfortunate. And I view an invocation policy for whatever all the arguments that were raised today, whether it is that El Paso is overwhelmingly Christian, or there's a large segment of the population that doesn't identify with a particular. I mean, it's an opportunity for I think everyone to get to know people of different backgrounds, people of different faiths, people who have no particular faith, people who don't identify with a particular faith. That, you know, I have known some you know, some of my greatest lessons, you know, of when it comes to ethics and morality have been from those who don't affiliate with any particular faith. And you know, I don't see what prohibits, you know, someone who doesn't identify, you know, with a particular faith from coming to give an invocation, or to just to give statements of goodwill to their governmental leaders. But you know, as I said, it's also an opportunity for us to hear from other faiths who perhaps feel marginalized in our community, because it is probably a true statement that it is predominantly Christian. But it's an opportunity for us to get to know one another a little bit better. It's an opportunity for us to learn from other faiths, and it's an opportunity from us to get to meet people that we perhaps don't interact with. I mean, how many people here in this room can say, you know, that those, I guess, that are Christian can say that they've interacted with someone of the Muslim faith recently, within the last recent. And you know, it's not, unfortunately, it's not as common as it should be. And when I look at our country today, and I just think that that's really a source of divisiveness in our country. And I think we need more things that bring us together. And I view this invocation policy as that. I don't view it as excluding anybody. I think we should be very proactive in reaching out to as many people as possible. And I say people, and not necessarily religious organizations, but just people who, you know, it's unfortunately, when it comes to people's view of governmental leaders, there's such a mistrust and almost this disdain where the interaction and the level of our civil discourse when it comes to governmental leaders and the public has also reached an all-time low. And I think everybody can agree, whatever your position is, whatever your faith is, that we need more things that bring us together as, and I view that this invocation policy is an opportunity for that. I know that there are always outliers, and there's always extreme examples. I saw on YouTube the video of, you know, the person who identified with a satanic organization, and you know, it caused this uproar. And yes, we always look to those, you know, those outliers. But on the whole, I think there's an opportunity for us to really come together through this. And I think everybody can agree that I think our country needs a little bit more of that. And I think that an invocation policy is a small step in that direction.
Well, it seems like there need to be some changes made to the existing backup that we had. And so I guess that work will continue and come back to the Commissioners Court on a Monday for a vote. I am also a Catholic, and I pray. During lunch, sometimes I walk to the church that's just down the street and sat there and prayed. And I do have a bit of a concern with we have always been a government, as Commissioner Stout mentioned, that is very inclusive and open to individuals. We have tried to maintain that, And not that this would necessarily change that, but it could, in that we in no way have the ability to determine who's going to be speaking during any Monday morning Commissioners Court meeting. And it would be a shame to open our meeting in a way that would make the public that is there to do county business uncomfortable. And if the prayer is meant toward the policymakers, again, I don't know why we couldn't do that on our own prior to the meeting. Even if we got together and did that as a group prior to the meeting, I'm not sure if that would be in any way a violation of the Open Meetings Act, but if it wasn't, that we could, or individually. Those are my concerns, that I would hate to put people in that position that show up to do county business. I don't think they attend for the invocation. Obviously, folks would attend to provide it, but not for that invocation. They're for the business of the county. And we've been very successful at not having any issues around that, and I would hate for someone's invocation to be the topic of conversation for that day. Going back to Mr. Davis, did we ever have any issues during the time that he was providing the invocation? I don't recall, so
I was not in administration at that time. I don't recall issues with the invocation itself. There were other issues, but not relevant, I think, to the.
Okay. It's been such a long time that I don't remember.
Yeah,
I was there, and there were really no issues with the invocation. And he volunteered to come himself, and he had worked through the sheriff's office, but he was a private individual. Okay.
So those are my thoughts for now. We obviously still need to clean this up, bring it back to the Commissioners Court, and put it back on the agenda for a vote.
We'll get it back on the agenda when we've put the policy together, and all of you, as you know, we'll post it with enough time, as we always do. But I can't thank all of you enough for giving up some of your morning to join us and give us sharing your information with us publicly and privately, as you did a couple of weeks ago.
We thank you for allowing us to come here. Thank you for opening the meetings.
Thank you.
So no action on item 6.
Would you like to go back to item 2, please?
Yes, please.
Thank you. Item 2, receive an update on the 2013 El Paso County Comprehensive Mobility Plan, vehicle registration fee, funded projects, and the El Paso MPO's 2045 Destino Metropolitan Transportation Plan, and take any appropriate action.
Commissioner, I was going to move to delete this item. We're going to receive a more thorough and comprehensive update in December, and I think that's probably a more appropriate time to give you a more thorough presentation where all of your questions and everything can be answered. Right now, there's a lot of loose ends that need to be tied up. As we speak with our transportation partners at TxDOT and the MPO, and I think we're already scheduled to get a presentation in December, and I think that's more than enough to go over everything and answer all of our questions and things. With that, I'll move to delete.
Second.
Thank you. Commissioner Pettis?
Aye.
Commissioner Young?
Aye.
Commissioner Stout?
Aye.
Commissioner Haggerty?
Aye.
Judge Vogt?
Aye.
Motion carries. Item 3, receive a presentation regarding compensation and training for prospective poll workers for the March 2018 primary election, and provide guidance on the proposed options.
Good morning.
Good morning, Judge, Commissioner. Sorry, I was running from my office. So I just wanted to take a couple minutes this morning and go over an issue that we talk about in our department. We talked about last primary, and I want to bring to your attention for this primary and just get some idea on direction and advice. So, okay, thank you. So I want to talk a little bit about the primary poll workers' compensation. As you know or don't know, the state of Texas currently pays primary poll workers an amount of $8 an hour. For FY 2017, the county had set the minimum wage at $10.10 an hour, and FY 2018, $11. So right now, what we had budgeted to do for this cycle was to cover the 210. So pay them at 1010. The state would cover the $8 and we would pay the 210. That's in our budget for this cycle. We had talked with the county attorney's office because they had said that anyone that worked for the county had to be brought up to these pay scales. Is that correct, Betsy, or no?
I don't think it was part-time workers though.
We never discussed poll workers.
Okay.
Because like, I don't think it doesn't include lifeguards and part-time work. And I think this is
Like the seasonals.
Yeah, seasonal.
Okay, so that's a little bit different information because she had told me that you had to be at that rate. So if that's not the case, then we can still look at these and decide how we want to handle that for this cycle at least. So right now, like I said, they're paid at $8. In our budget, we put the amount to cover the 210 to bring them up. So that's one of the options. And if you look at the second page, it talks about what that would cost. So the options are the state pays the poll workers $8, we pay nothing and keep them at $8 an hour. Right now, when we conduct any other election, we pay them at 1010. So the city elections, anything like that, we are reimbursed from the city for those costs, or school districts, whoever does that. The option 2 would be the state pays the poll workers $8 an hour. We pay the 210, which is what we had budgeted for and what you approved in our budget. This amount, approximately $40,000, is already included in our department's budget. Or the state pays the poll workers the $8 and the county pays the additional $3, bringing the poll workers up to $11 an hour. This option would require an additional $14,000 to come from our special revenue fund, not the general fund, but it's a special revenue fund where the money that we charge the entities for conducting their elections, then they pay us back, and that's what that revenue fund is in. So before we move on to the next question, if we could discuss this option, what are you? I was under the impression we had to be at that limit, at that level, so that's why I wanted to put this on the agenda. But if that's not the case, then there's a little bit more wiggle room on what we can do.
Well, I guess the only concern I have is if we're paying $10 an hour on all the other elections, and the big elections we're paying $8, I can see where poll work would be a little miffed.
And that's the issue that, I mean, we did have last time is we had a lot of people calling and saying, are we going to get paid the same amount for the primary that we do for when we work for the city election, when we work for in November, when we work for any of those other elections. And so that's why we had put that in the budget, so that they would be paid the same.
What kind of impact would you saw the $14,000 if we bumped it up to 11? Because I think we should pay 11. I think we should do it
I think
across
it would
the board.
54.
So the 40 is what would be the 10, and that's
Right,
already
but
in our
that's already
budget.
budgeted for,
Yep.
yeah.
So it would be an additional 14,000
Right.
to
So what
bump it up.
I mean, what kind of impact does that have you on other expenditures that may come out of that pot?
Well, that would come out of the special revenue, which we have about $954,000 in right now. So it's, you know, it's not a huge amount at this point. And then we just have to make sure that when we start to bill our entities, and we get we have our new poll books coming in, and we have our new equipment hopefully in the next 18 months, that will be reflected in what we bill them, so that we can keep that flush, keep coming in and making sure that stays at a certain level to pay for everything that goes through. So we have enough money right now, obviously, to do that. We just need to make sure that going forward, when we decide on how we're going to bill these entities with all this new equipment, that we keep that in mind.
Lisa, may I ask? So the 14,000 is paying them $11 for all elections, not just.
It's right. So what we would do is, right now this election would be the March, the May, and then hopefully the next election would be in the next fiscal year. So then in our next budget, we would put in for $11 if that's what the direction was, if that's what the consensus was.
Yes, I'm also in agreement that in this particular case, we can't cherry pick and say, well, in this we're going to pay them so much. That we should make it across the board for the election judges, that we do pay the 11. Is it 11.10?
$11.
$11 an hour, and it has a $14,000 impact. And as you go through your budget throughout the year, then if you start seeing that there are problems towards the end, that we revisit with Wally to see what we can transfer to make you balance out.
Sure, sure. And like I said, that will come from the special revenue fund. It's not from our.
It won't come from our GR, so I mean, we can pass that on to the people that we're contracting to, the other entities that we're contracting with.
I could tell you today, if you were to make that change effective immediately, your special revenue contract services funds has adequate funding available, and it would be billed to the appropriate entity.
So then those entities, the one thing you'll have considerations for is they may have not budgeted for $11 an hour. So it'd be like us getting a bill with a 90-cent an hour increase that we had not budgeted for or been put on notice for.
And so we did have a situation in the last, we did have a situation in our last, not this, but with the city of Socorro had numerous elections this summer, and they did not have, at that point we were doing the 10-10 budgeted, so they took on some costs, basically things that we would charge them for, printing and things like that, on their own. So it really wasn't much different, or they went from 4 poll workers to 3 poll workers, which they thought they'd be able to do, and they were fine with that. So we do work with them, and we have given them all kind of a heads up that, hey, now that we're getting these electronic poll books, now that we're getting these new voting system, hopefully in the next 12 to 18 months, there will be an increase on that part of it, and they'll have to account for that.
And Lisa, I've got to say that for the most part, the poll workers are very friendly, and many of our voters are one-time voters. They're iffy voters, and it makes a world of difference if they're treated professionally, they're treated well, they're helped through the process, and for the most part, I think those poll workers do a good job, and I think this goes to demonstrate to them that they're important and they're being compensated fairly for their service.
I agree with that. I just want to make sure that that's kind of the belief of the board before we move forward, because the next point kind of talks to that about the professionalism and that kind of stuff. So if I'm getting kind of the feel for the direction is across the board 11 and keep it at that.
I think as long as you can continue to work with some of these entities that did not budget for that,
I think
because
if
I would hate
there's
to.
small entities, it could be a huge, drastic amount of money we charge.
Now those entities, when we talk about the elections that are going to happen before they would go to their budget, a lot of them go in June. We're really talking about the March primary, which is not the entities don't participate in. And then we've got two entities who have told us that they're going to try and do something in May, very small. We had someone who passed away from the Vinton city, the Board of Aldermen. They're going to have a replacement election in May, and the town of Clint, which just forgot to call their election, so they are going to have to go in May. Now they were scheduled at 10-10 an hour, so it will be a little bit, but again, they're one location usually for early voting, and we've talked with them about how in 2016 they had 4 people, and if they go down to 3, which is allowed by law, they should be okay, especially in that small of an election. So we will work with them, and then going into the next budget cycle, letting them know, and like I said, we have told them that there will be an increase on things like this. Okay? All right, then I'm gonna go to the next one, because this one is a little bit more, I think there's a little bit more to talk about on this one, which is that the state does not pay to train poll workers for the primary elections, okay? And we have had, the only primary that I've been here was for 2016, and that was reflected, I believe, in the fact that a lot of these poll workers did not go to training. If they're not offered pay for their time, a lot of them opt not to do that. Every 2 years we have changes to election code, just like with the legislative session we had. Things that address the voter ID law, things like now that someone who's disabled can be moved to the front of the line. There's a lot of things that are covered in training that have changed since the last training event attended. So a couple of the options here, of course this is going to be another fiscal decision. So this is the choices we can do with the training. County offers no compensation, the parties offer the training, and try and get as many people to go as possible. That's basically what's happening now. County offers 3 hours of training at 10-10, which is kind of a moot point now because we've said that we're going to pay 11. I don't know if training would make a difference if we wanted to pay 10 at training and 11 at service, but requiring a budget increase of 17,575 from that special revenue. Or C, county offers 3 hours of training at 11 an hour, requiring a budget increase of 19,140 from that special revenue fund. So this is where we have to decide, does it benefit the entire county to have these poll workers trained? And if so, does it benefit enough for us as a county to pay for that?
What do you say?
I think yes, because I saw firsthand what happens when they go to when they have no training. Now I can't promise a perfect election, even if they go to training, but I can tell you I think it's worse when they don't, in all honesty. But I'd be willing to say that, hey, if we want to pay the training at a different rate than we pay at the actually at the polling place, I think that's okay. I don't think that's unheard of, but I do, you know, I'll look to you for direction, but I do think training, a consistent training, because when they go to their parties for training, there is definitely a different level, a different training than what we do.
I have one question.
Sure.
Okay, so you want to pay this out of your contract, election contract service fund, but are you billing the other entities for this?
We wouldn't be able to bill the parties for the training because the state will not reimburse that.
My concern would be that you're making some major expenditures out of that fund, and as you ramp down on those funds, which you're not getting reimbursed for, that would cause a problem. But at the same time, you're making a point that it's not something that really may not qualify as an expenditure of that fund because it's really affecting the whole county.
And that's the issue. I mean, that's the issue that we face with the training, in all honesty, is what is the value to the county to have trained poll workers? Now it is the party's election. It's the Republican and Democrats party election. So if the feeling is, hey, we don't want to start doing this where we're paying them to be trained, let's just leave it in the party's hands, then that's fine. But just so you know, I do see an inconsistency with that. And I saw it in 2016, pretty severe.
I'm going to agree. My mother went to vote one time and had a military ID, and it says very clearly the military ID is a valid form of ID, and they denied her the right to vote because she wanted to use her military ID. She was very angry and yelled at me. I've had experiences where a lot of times people come out and start screaming things, and like, it's not rules. And it's very, I think, hit or miss as far as if they've been trained or not, what the rules are, what they aren't. And I think that's the problem is these people, you know, people will go to a site and be told one thing, they go to a different site and be told the exact opposite thing. They start to have that's where the mistrust of government starts to come in as well. So if there's a way we can find a way to require training, especially if we're going to be paying 10 or 11 bucks an hour, I think it's definitely, it would be good, because I know I've received a lot of complaints from people saying, I've got a military ID. It says on the paper in the freaking room, I can use military ID, and they're not letting me use military ID. And I think those are issues that we need to make sure we're getting addressed, because we're denying people the right.
I agree 100%. And as I mentioned earlier, if we don't have people that are trained and we have those one-time voters, they're never coming back. And one of the questions that I have, I'm supportive of the training. I think it's a must-have if we're going to do a uniform from poll to poll. My question is, if we train Lisa Weiss, I don't know if it's 3 hours, whatever it is, then Lisa decides, well, I don't show up for the actual work. What happens then?
Well, unfortunately, we have that happen a lot of times, where we will have poll workers who on any election will come to training, and then on election day, something will happen. Now, we have had people who've gotten in a car wreck, whose husbands have had a heart attack, but they still will be paid for the training because they did attend the training. But they would not be paid for their work on election day. One of the other things that we do now is we have what we call an extra board, which is basically extra people. So we ask the parties, if they can't do it, we go through a temp agency. We bring in 10, 15, and in 2016 we had like 30 extra boards, where they came in, we did a kind of a brief training with them, and then we're able to send them out to places that were missing people. And it's worked okay so far as that goes, but we can't not pay them for training even if they don't show up, because they actually did put in those hours. So we will pay them for training, but if they don't show up to the polling place, then they would not be paid for their service on that day.
For example, do we have to provide training every year? Because I know in my polls I see the same people. I mean, I've seen some of the same people over the last couple of years, right? So that's one question. And then the other one is, so Ed was talking about, depleting the special revenue fund. Is this something that we can maybe take out of the special revenue fund this time and then maybe include it in the regular budget for the department going into the future, so we don't whittle away that fund every year?
That would be a question probably for Wally, in all honesty, on that side of it. But as far as the training, I can answer the first part. We do offer training for every single election, because honestly things change, and we still don't ever have 100% what I would call perfect election, and until we do that, we will offer the training. A lot of the areas, the ID law keeps changing. We've got issues with the provisional ballots. So especially now we're gonna get our new poll books. So we will keep providing that training, except for the primary, and we pay the training for the early voting for the primary, because that's how the law is written. The county covers all the early voting costs. So any other entity, they really do pay for the training. I mean, we train them, but then they reimburse us for whatever we've paid for. But yeah, we do keep offering it. We have some people who don't love to continue to come back, but a lot of the times, especially now that we have snacks, it seems like we get fewer and fewer complaints. They don't mind it. We've offered it now instead of just here. We go out to the east side, we go to the northeast, we have a training on the west side. No one has to drive that far. So we have had a better, I think people are more receptive to the training. But yeah, I mean, until we had 100% accuracy, I would continue to offer the training.
Judge, I was wondering, and Lisa, maybe, so if the parties currently offer training to the poll workers, would it not be possible for us to offer to the parties to provide a training but at a fee?
The only issue is that the state won't reimburse any trainings at all. And so the county parties would have to pay for that on their own, and they've been very clear that they don't have the funding to do that.
Okay.
So now we could give them our training and say, here are the trainings that we would give to the poll workers, and they can give that as they like. But again, they're still probably talking to half of a room because they're not paying either. So, and everybody does it a little different. There are different things that each party wants to make sure they cover.
Sure.
And so I have seen a little bit of inconsistent on what one party trains and how the other party trains.
And just on that note, that was one of my questions was, is the concern the quality of the training is being done by the parties, where we're not seeing the kind of training that would lend to a better poll worker. And if that's the case, then maybe we still have to go in there and try to revamp their training, whether they get paid for that or not. But and the other question I had was, is there any way, and this may not be possible, to incentivize going to the training where if you complete the training, you receive a certificate, and at that point, as a worker, the day of election, you would be paid the $11 as opposed to maybe the standard $8, so that it would incentivize them to have to go to the training to earn more. I don't know if that's even possible.
I think that is possible. I mean, the certificate is maybe, I think the parties, I know the Republican Party gives them certificates, but maybe having them saying that, hey, if you do go to the training, you'll make $11 an hour instead of the $8. I don't know if there's a legal question on that.
I don't see any prohibition on that happening. I'm not doing that as an incentive. I can't think of one off the top of my head.
And I mean, the only issue is we may get people who we ask to be on the extra board who say, well, yeah, I'll come in at the last minute, but then I'm only gonna make the $8 an hour where I would have gone to training if you would have offered me that. I mean, there's that kind of deal, but it's a small number where if we do a decent training, on the morning of the election, which is when they usually come in like at 6, and we train them till 6:45 and then they go. I think that would be something that would be decent. I mean, then we're just going back to that $11 pay. I hadn't thought of that, and I think that's an option. I mean, if there's no legal side to that, of offering that, hey, if you did attend training, you'll make 11, but if you didn't, then you'll make 8.
And I think it makes them want to go, one for the pay,
Yeah.
but also to pay attention if they know they have to get some kind of certificate that, you know, there won't be an exam at the end of the deal, but that they should really be up to speed on what the new regulations are.
But aren't we back to the same problem for people that say, I don't want to go through a training, I'll just go over there. Then we have a lot of untrained people.
Well, then you have the people who say, I'm willing to make $8 an hour, and maybe they're not that high quality. So that's the side of that. If people are willing to say, oh, I'll just take $8 an hour.
And there's no way you can just mandate that they take the training if they want to work.
No, and because it's not ours, it's really not our election, they're contracting with us to do it. My mandate power is pretty small. Now on the early voting, yes, and we do mandate it. You have to come to training. Even if we've had people that were sick for a week and they've come in on a separate day and we've done a training for them. And so we do that on the ones that we can do that on. On the party side of it, it's really hard to do that. It's up to them on how they handle that. So I've spoken with them. You know, they've said, look, if you want to do the training, that's fine. We want to see the training ahead of time, which is, I'm fine with that. But
it's up to the parties then to say whether or not there are people who have to take the training or not?
Well, they say they require, but there's really no way to require because you don't pay them to come or not, and so there's no penalty really if they don't. And in all honesty, as you get closer and closer to election day, people are dropping out and they're panicking, and whether people took the training or not, they're just putting, bodies in there to try to fulfill the requirement of 3 people per election site. So I don't know what the best way to do the training part is. I'm fine with the $8 and then the $3 incentive. I just want to make sure that if people are saying, hey, I'm fine with $8, then I don't want to have, and it's one thing if there's a polling site that has 2 people who were getting paid $11 and took the training, and the other people are $8. But you need I would at least want someone at that location that's had the training. That's the big issue, is a whole entire polling site staffed with nobody. Now, we could try it for one election, the 8 to 11, and see, do we get 80% turnout where there's at least 1 at every polling site, 2 at every polling site that decided to take the training and get paid $11 an hour. It's really, what we think is best.
What are the average hours they work at an election?
They get there at 6 in the morning, they're supposed to, and then they stay till, we say about 8 at night. If they close at 7, then they have to take all the machines down. Usually the clerks will leave at 7, and then the judge and alternate judge will stay an extra hour.
It's like a 14-hour day.
To take down.
But this is I assume this is all for primary, which means you've got 14 days of it, right?
This is just election day.
Yeah.
On early voting, they're different. There's 8 to 5, there's 9 to 6. We have some sites that are 10 to 7.
Well, what is your average election hours per volunteer?
On election day?
No, for
the process. So they work early voting and election day.
How many actually is kind of like the breakdown?
Yeah, because
how many work early? How many?
If it's 70 hours, 70 times 3, I mean that you're getting $200-300 more for going to this training. There's a value to going to the training, plus you get paid for going to the training.
Right.
So I mean that's the way to look at it is if you're going to work 40 or 100 hours over this election cycle, it's $300 more just for going to this training.
Right.
Well,
we would pay our early voting people the $11 because we mandate they go to the training. So if we decide to go to the $11, which we as a county are required to pay for the whole early voting, it's almost like 2 separate elections. We're required to pay early voting, we're required to pay training.
So this is just election day?
This is just election day we're talking about, because otherwise we are in charge of that.
Because election day, there's 180 sites.
Right, there's,
Okay.
right, so, and there'll be, 191 precincts and 145 election day sites right now. So, that would be the cost we're talking about. And that's, I would say it's an average of 13 hours. 13 for the clerks, the judge might stay. This one may be 14 because they'll be there an hour before and then an hour after. But it really also depends on the election. But the clerks usually get there right a little before 7 and leave right at 7.
You're talking about extra 40 to $50 depending on.
Yeah.
It's not a joke.
You're talking about initially.
Not only that, you're also talking about the training hours.
Right. Yeah.
But the training hours would be what? That's what we're talking about, right? The training hours would still be paid.
If we paid the difference,
No, but it's training, because currently we don't pay the training, so it's an additional 30 for your train, and then to work an election on average, 13 to 14.
It's a custom. It's a custom in practice from here forward. I'm not sure. You're talking about the pilot doing it under special revenue, but then the county doesn't.
It would turn.
I'd like to add on to that for budget purposes, and answer Commissioner Stout's question. So if we looked at, if you did it for year 1 out of your special revenue contract services fund, but thereafter, if every other year, the election costs are cyclical in nature due to the nature of our election cycle. So postage goes up for mailing out our notifications, and then our election costs go up. So if we were to consider going that route, I'd urge us to get on that same legislative election cycle. And every other year, that's about a $20,000 bump in our election costs on the general fund side.
I mean, I even thought not pay for the training, but the incentive was just pay that added $3 when you work.
And that's basically the paid for the training, is what you're saying.
Kind of, yeah. Like you would part of your work that day is to get this training, so you show up to the training as part of the requirement, and then once you decide to show up and work.
But what would we do if for some reason they couldn't come to election day? We'd still have to pay them for the training, right?
No, so the way you do that legally is you make the training voluntary. You do not have to attend this, you're not gonna be punished if you don't. But if you do attend it, we will pay you $11 an hour. If you don't attend it, we pay you $8 an hour.
That was just my thought.
The other way though, the other way to do it is say the training is mandatory. You must be there, we do pay you, and you have to attend. And then that way you get 100% attendance. But we have to pay if we make it mandatory.
I think that's the better way.
And you don't let them work unless they've got the training.
Which can become a nightmare coming down.
Yeah.
It can. What we really try to make sure is that we have the judge and the alternate judge trained. If for some reason we have to find a clerk who basically just does what they're directed to do, the training of that person is less important, in all honesty. Because if you have a judge and alternate who are trained well, then the clerk kind of just does whatever they tell them to do. And the training is not as important as at least having the 2 people who know how to do the provisional, know how to do curbside, know how to reboot a machine if they need to. That's the most important. And then having just somebody there to, check people in or check an ID or sign something. That's kind of how we do it, is that those 2 have to be trained, and then if we are short a body, then that person is a clerk.
So Lisa, in your opinion, if the court pays $11 for the training, and for the certified people that go on to work the actual election, if they have the certification, then they get $11 an hour. If they do not, then it's $8 an hour. Are you in favor of that option?
So the training would be $8 an hour flat. Is that what we're talking about?
$11 for the training.
Okay.
And if you work the election,
okay, you
will also receive $11. For those that didn't have the training, then it's $8 an hour.
So then that would be the $11 for the training increase here at the 19,140. And then probably a little bit less for the 14,000, because honestly, not everybody will probably do that. I think that's fine to try at least 1 year and let's see how that works. And we can, you know, create a policy and decide to move it over to the general fund for every other cycle. We can push for the state to push for training, you know, whenever we go back to the legislature. So I think that would be a good place to start.
So we would not be mandating that in order to work election day, you had to have training. It's still open.
It would still be open, but if you don't do the training, you miss out on $11 an hour for the training, and then you only make $8 an hour. I mean, that's a big difference.
You can't make it mandatory for the judge and assistant.
Yes, we can, and just tell them we can make it mandatory however we want. I would want to mandate at least the judge and alternate go to the training, because I don't want to be stuck with an election board with nobody who opted to do that. And I think if you've taken on the role of the judge, the alternate judge, then you have more responsibility, and one of those things is you have to do.
So it sounds like $11 for training. For those that are trained, $11 on election day. For those that aren't, it would be $8. Does anybody have any concern with that?
Sounds like a plan.
And so for this year, you'll go ahead and pay that out of your special revenue fund, and then we'll consider it during the 2019 budget cycle to include in your budget.
Any other questions or comments? Thank you, I really appreciate it. Thanks, guys.
Thank you so much.
Item 4, receive a presentation on the 2018 retirement rate recommendation from staff, Texas County and District Retirement System.
Good morning, Judge Commissioners. Wally Hargrove from the Office of Budget and Fiscal Policy. During our budget process, we went over the retirement rate, the annually determined contribution rate that we received from the retirement system. Also reviewed our unfunded, actually determined unfunded liability on our pension plan for the future. In that process, our annually determined contribution rate for calendar year FY18 goes from the current 16.45 to 16.78%. Our goal was to begin paying down the future unfunded liability, and stands at $146.9 million by making additional contributions. We allocated $500,000 in the budget towards this goal in FY18. Myself and Ms. Melissa Carrillo met with staff in the retirement system and discussed our best practice and recommended strategy. Staff from the retirement system said one-time lump sum payments tend to be less impactful to the long-term unfunded liability. That choosing an elective rate increase is the most common practice taken by counties and easier to fiscally maintain over time. I did not get the listing of the counties, but I did receive an email from the retirement system yesterday that 89 of the 254 counties are currently choosing an elective rate above the annually determined contribution rate. So that's about 35% of the counties are electing to go above. On average, those counties are choosing to adopt a rate 1.99% above the annually determined contribution rate. So if we were to go all the way there all at once, our rate of 1678 would go to 1877 if we were to be on average like other counties in the state are doing, 89 counties.
Sorry, Wally.
Yes, sir.
What would that look like financially if we made that large of a bump?
So I'm gonna get you that number right now. So our long-term goal would be to achieve somewhere between 1.5% to 2% elective rate buildup over time until the plan is fully funded. That ultimate goal could be higher or lower. That's all dependent on a number of factors. How many employees we hire during a year? How many employees choose to retire? How many employees pass away during the year? How many employees don't take monthly retirement contributions but take lump sum payouts? So there's just a plethora of options.
Quit at 6 years and don't
right, yeah, quit at 6 and leave their take their money out. Or leave it there and just draw 7% interest until they take it out in lump sum. So it's just so many factors. But from a fiscal perspective, the rate to get close to, and I say close to because all these factors can impact our ultimate payout, That would be the recommended elective rate. It would be to go to 17.13%. That's about 1/3% higher. At that rate, all things remain the same. It would take us just over 5 years to get to that 2% recommended elective level to pay down our unfunded liability. Certainly our goal is to pay that down. Things that could impact that rate in the future. Market performance. If the market continues to stay strong and pick back up, that we could get to that unfunded sweet spot rate sooner. But if the market goes the opposite direction, then that would perhaps take us longer than that 5 to 6 year range. Every year from hereafter, our budget calendar will take that into consideration. But right now, that rate of 17.13 approximates the overall impact to utilize the $500,000 appropriation that the county set during its budget hearings. And with that, I would open it up for questions.
But then that would be an annual appropriation.
Yes, that would be that would be an appropriation for the calendar year 2018, which we would need to fund the last 3 months of that calendar rate in FY19, because our FY18 contribution was $500,000. It's January through September. So we've got to appropriate October through December because that's next year's budget for FY19.
Could it, I have a
an
question.
additional $167,000.
So I guess maybe it's a question. I mean, could then we bump? Because I don't know what the commissioner's court intention was by setting aside the $500,000 if it was a one-time deal. Could we do a one-time rate increase and then do an elective 1 year and then non?
You could, because what you could do is you could base that determination on how does market do? What's our experience rate? How many people retire?
I think what we're meaning
but
is.
what most entities do, and that's why they recommend going to an elective rate, most entities hold that elective rate higher. Even if their annually determined rate goes down, they stay at the higher rate because they pay down.
But I think what we're saying, Wally, is to make the $500,000 one time, plan on carrying it over, don't plan on using all of it this fiscal year, bring the rate down, the 17.13, so that we annualize the $500,000 on a calendar year.
Okay.
So that we're not locking the court into a budget decision for FY19 today.
You do it for a
So
calendar year
recalculate every
18.
year like we did this year.
Yes, sir.
The effect of a 500.
So it'd have a little bit of a
based on what they
smoothing. It would
suggest.
have a little bit of a smoothing event. It would probably take longer than that 5.6 years. Might take 8 years to get ultimately at a build-up. I can run that number. Again, this would be an approximation. I sent this calculation to Mr. Dion. He confirmed that was the right approach to take.
So $500,000 for a 12-month.
And I think what Wally is saying is if your emphasis is to reduce the liability, that 500,000 built in will hopefully start getting your TCDRS rate to go down. And the longer you keep that rate or even ratchet it up another 5, it's going to cause your liability to keep going down and TCDRS's rate going down. Because your liability will be less, so therefore they say you need less for the future.
And I agree. I understand. I don't understand how I say it makes more sense to pay it over 12 months than to pay it day one. That simple power of money tells me that's not true. It makes more sense to put the money in our account today than to put $500,000 divided by 12 a month in there, because we're getting less return on our investment every month. We're not putting it in the account.
They're getting actually less.
Yeah, it's been spread over time, but I think for them it's a complication in their system to apply it.
I call a little bit of BS on it doesn't make sense to put the money in today.
I think they think it makes it easier for decisions in the future.
I think what it is it's easier to
Keep that
say.
rate.
I think it's easier to tell a court, raise your rate because you'll keep your rate raised, and there's a chance you'll keep the rate raised than to pay it all at once. I don't believe that it doesn't make more sense to put the money in today than to do it over time. Now, I mean, just the simple. It's like, or what makes more sense? Put $500,000 in your savings account today, or put $80,000 a month in your savings account. What's going to do you better over the long term? $500,000 today. So I think what it is, it's a mind trick to courts to say it's easier to keep your rate at a higher level, and it's easier to explain that to a court that doesn't, some of which don't understand the power of money. But to tell me it doesn't make more sense to put the money today, I'm not going.
I guess the example that comes to mind is I remember calling Collin County, dumping millions of dollars.
And then
they're over 100% funded. I mean, actually don't. So I don't think they did it in their rate, I think they did a lump sum.
Right, and the lump sum makes, I think what it is, it's easy to explain to a court, pay an extra percentage every year than to pay $500,000. But I get it, I just don't agree with keeping the money in our account making 0.001% interest or putting their account making 7%.
I think the only other thing, and Wally, correct me if I'm wrong, I didn't attend that meeting, but I believe the only other thing that I did read on this, when we were originally talking about this, I read something about when they actually go in and start, so a lot of your unfunded liability, you know, there's an actuarial study that comes in and looks at the account. And that when you have increased your funding percentage, that's taken into account on that actuarial valuation. And so that may be a slight factor in why, if you've voluntarily raised your percentage, it may have a factor in how the actuarial value is determined of what percentage is funded. But that's the only other thing I can think of that would be a factor to the positive of doing the percentage increase.
So I reran the number to effectuate a fiscal year impact for our 9 months of the fiscal year, 375,000, knowing that the last 125 would come out of FY19 for the total of the calendar year, and the rate drops down to 17.03. So it's a quarter of a percent increase if we go to a rate increase.
And the only thing that could impact that is if the court next budget cycle changed wages.
Correct. Does wage increases, add positions, delete positions, and then all the other factors of deaths.
That's based on our current payroll.
Based on our current payroll.
On those fun accrual charts if they love that.
Oh yeah.
I don't understand how not putting money in state. I'm not thankful. It doesn't make sense. I'm not that schooled in the actuarial side of why a rate's better. I think it's more of that psychological. It's easier to get a rate, keep a rate, maintain a rate.
So how many years do we have to do this to catch up?
It was six on the rate of 1713.
Right. But to pay it all
no, six gets to that 199. It gets you to that 199%. To pay it all off, oh gosh, I can't. That's a handful of darts at a dartboard because market performance going up, market performance tanking.
Okay, they came and gave us a report though of how long it'd be before we'd be caught up, and it wasn't that long. And with this, they said it would increase.
If we're putting $500,000 a year.
Wait, are they talking about laddering that on top of every year?
No, it was not laddering. It wasn't even. It's like 13, 12 to 13 years.
It was somewhere between 13 and 15 years.
We got that during budget, and they told us that the plan is already designed. The rates are right now already designed to catch up unfunded liability. Everybody's plan is designed to catch up on unfunded liability. And they told us that originally they had done it based on a 20-year pay down. But we're happy to report that it is actually only taking about 12 to 13 years.
It's in a 13-year range. But again, that's all
in the
under
current
the assumptions
design,
that the rate design and the market performance and population stays like it is today. It's a qualified. Yes.
With no added.
No. The rate's going to always be changing.
Right, but
the design is
at the current design.
The current design
Yes.
will get there around in the 13-year range.
So with our added contribution, it should expedite that even sooner to be catching up our unfunded
With
liability.
the $500,000, it should be catch up sooner. And if next year we put in another $500,000, it would be sooner.
It would be the same 500.
Yes, sir.
No, it would be an additional.
Well, no, it's 500.
The same 500.
And if you keep the same, then yeah, you're gonna get there. You're gonna get there sooner. I
Well,
wish I could tell you it was 9 or 8.
Well, in your opinion, it sounds like we're relatively healthy as compared to other counties. I know the city's got
Just under
big problems.
84%. I think the chart I didn't have that in my PowerPoint, but I think I have the chart in there where it's just under 83.4. Yeah. So if you look at the average in the plan is in the mid 80s, in the mid 85, 86. So we're not
Which is
far
healthy
off.
when you compare it to the system as a whole.
It's healthy when you compare it to Detroit, but no, I'm sorry, we're not. I mean, our job is to be fiscal stewards, and I'm sorry, low 80s is not where we need it.
No, we should. I mean, it'd be great to be at 100, but I think
90s, I think, is where we need it. I mean, realistically, because if the tech market crashes tomorrow, I mean, you don't know it. I mean, I to sit there and say we're relatively healthy compared to what, to the El Paso Fire Department a couple years ago. Yes, absolutely. To Detroit, no doubt. American Airlines, sure, but we've got to make sure our retirees get a check for the rest of their lives, and low 80s is not where I'm going.
And so this bump would get us to what percentage? Do we know?
No, I don't. And because it's all relative to market performance as well. And who decides to retire between now and December passes away.
And then I think the court is now, I think, more aware of issues like COLAs. You know, I had a note on an old presentation that the court had frequently given COLAs, which is typically not really recommended by TCDRS because they amortize that COLA over 16 years. Which
the assumptions they run is they're always going to get it because our history has shown that.
Right, yeah. and they amortize that over 16 years. So we end up paying that one COLA. It takes 16 years to pay off. So if you've stacked on COLA after COLA after COLA, and I mean, that's certainly something that I learned going that, you know, I didn't realize that it was amortized in such a way. But now that the court is a little bit more cognizant of that and is not giving it as frequently, you know, maybe they might decide to at some point in the future, but that factors in as well.
Absolutely. I mean, so we're on the second year of not giving a retiree COLA, and we had that discussion with our team, and as time proceeds, if we start giving that COLA on an occasional basis, it will impact the long-term amortized, annually determined contribution rate. So
and should decrease our liability.
Should, yes. So again, the combination of additional contribution and being more attentive to how frequently we give the COLA can start pulling those numbers back toward each other and increase those low 80s to
and I think we just need
the 90s.
More info on that. I mean, the plan customizer, I've never tried it, but it allows you to do all that and take all that into consideration. So if the goal, let's say, is the 90%, we should be able to determine how long or how many $500,000 contributions and how frequent or less frequent of COLAs should be able to get us to where we want to be, right?
Right.
Theoretically.
Yeah, theoretically and to a certain extent, because they've got a lot of qualifying.
Well, I mean, there's always going to be market conditions. There's always going to be deaths. There's always going to be. You listen to actuarial sit there talk for an hour, and it's life changing. If they die, we win. You know, those are the situations where we've got to figure out. But we just got to make sure we're in this situation. Next year, we want to set up a rate on pilot. I still don't agree that divvying up our payment in there over the next so many months is better than making a one-time payment. I think I understand where they're coming from, where they're trying to change our mindset of making it a rate rather than a one-time contribution. Yeah. Because a one-time contribution could stay a one-time contribution, where the rate could be a rate. And that's something I think we need to talk about next year.
That's fair, that's accurate. Yeah, I think it's good.
And something I think we need to talk about next year, but I don't agree with sitting on the money and making next to low interest when we can put it in there and make more interest.
So today's no action, today's for information, but our intent is to have the item on the agenda November 27th. The latest we can have it on the agenda is the second. It has to be approved and sent to the retirement system before December 15th. But our plans were to have it on for the 27th. So at that point in time, we can go the route of 1703 to have a $500,000 calendar contribution, or we can make a one-time lump for the fiscal year of $375,000 and appropriate the other $125,000 for that portion of the fiscal year for the last 3 months. And any other contribution the court wanted to do in calendar year 19.
But I guess here's my other question. We budgeted this in budget to pay $500,000.
Yes, sir.
Why did we do that?
We can only do it in December.
Because your plan is calendar year.
Okay.
You make one election period per plan.
Okay.
And when we do that, we'll say we want to keep this rate and give 500,000, or we'll say we want to bump our rate up. But that's why.
All right. That makes more sense. This is a month ago.
And then just, this was, I mean, the latest information I had, just to be clear, is this was as of June 6, 2016, but we had the highest required rate probably of any of the 254 counties. I just looked at the largest counties, and we had the highest rate. That was when it was at 16.45. I don't know if that's still our rate. I think it went up a little bit. It did go up in 2017.
1678 right now. I can see. I can before the meeting for the 27th. I'll gather the top rural counties. And you know me, I've talked about the how generous our retirement system is, but and Montgomery County also has similar where they put in the 250%, but I guess they've also done an elected rate that's higher, so the required rate is lower. So I don't know if that's probably the contributing factor.
I think the COLAs is what has put us in a situation where the continued COLAs over the years, adding up on each other. I think that if we solve that problem first and we start getting this rate, I think we'll be working.
And what's the, two more questions, what's the annual appropriation for that, to meet that our current rate of 16? But what is it you said?
What's the total? For next fiscal year?
You said 16.1.
7, 8.
And you have that one on yours. I think it's about $22 or $23 million.
I know. Okay, it was in the attorney name, right?
Yeah, it's about 20. It's between 22 and 23 million.
And then the other question I had. So TCDRS. So they send us every year information about our plan, and for several years, you know, they give you the example of somebody was hired at 35 and they retired at 65, and how much their final. How much their
actual
retirement would be replaced, and for the longest time it was at 100. It was at 110% after 30 years, and then suddenly it just recently changed to 98% after 30 years. Does anybody know why that happened? Because that was a question that I had as to why. I mean, to me it made no sense that you made more after 30 years than what you actually earned in your salary, and that was always the question. That was for years, and then it suddenly changed now to 98%, and we haven't changed any benefits to
I know they changed. I can track down a document on that. I know they sent a notification of changes they were making in plan design, but I don't know if that's the 110.98 answer.
Can you repeat that again, Vince?
So they gave us. So I mean, there's this chart that they give us for every year. This is like sort of our plan assessment, and they kind of give you a scenario. If somebody was hired at 55 and they retired at 65, you know, that they would retain 28% of their salary, assuming that they met the other retirement requirements. And then, but somebody who had 30 years of service, so let's say somebody that started at 35 and then retired at 65,
110
would retire at 110% of what they earned. And that was always my question: is to
how can they make more in retirement?
Than what they actually. But I guess I guess it was mentioned it was because of the savings and the market performance, things like that.
Because of the percentage that the market may perform at, and
right, and so this was 2016's figure, and then all of a sudden, for 2017, with no changes to our plan, it's gone down to 98%, which is, I mean, still, I know of no other plan.
That'd be performance of the overall plan, your investment earnings, everything, and the projection. The actuary every single year, depending on which actuary you get, you're going to get different numbers.
And I do know
68.
They did say that they do. I was reading that they do a full actuarial experience study every 4 years.
Well, that's a projection.
Based on, so you know they project, but then every 4 years they go back and study that versus actual, and that may be a factor. They go back and study the actual. The projection was 110. Then they go back and do a study on what actually happened. And that may be a cause for, but they do an actuarial experience study to compare versus what they projected versus actual.
My question on that, and this is, it was just as an example, we guarantee 7% return. Or they're
I think it's 8%.
It's
huh?
I think it's 8%, isn't it?
That's
no, it's 7%. It's
7%,
7%, and it's in the statute.
So
it's a
it
statutory.
doesn't matter what the market does. If I'm guaranteed 7% return, my return is going to say now what the counties have to pay to match that return if we didn't get it, or that is different. But the employee should get. This is what I'm guaranteed, whether the market's there or not. That's why I don't understand why the numbers change.
I mean, yeah, that's actually a good point because it's sort of
It
like
could be, but I don't know.
Well, you're guaranteed at least 7%, but doesn't mean that it may be more. It
But
may be 10%.
on the long-term
right?
No, that's where
No,
that's where they make their money.
That's where the rate
So you're-
decreases.
You get 7% guaranteed, and then we match. Now, if they get 5%, we have to write them a check for the difference every year.
It's almost like this artificial return, stock market return, where it's a guaranteed.
Well, a lot of that's based on when you do your own analysis on the system, they'll tell you what do you project as your cost of or your increase in your salary for the future. So sometimes the county gives a COLA, sometimes they don't. So if they project that one year that you're giving a 4% and they build that into the future, next time it went down to 2 or 0, I think that probably, to me, that would be the main thing that would affect your long-term benefit.
Yeah.
As how
But we're
much did
still
your
a-
income grow over
Yeah.
that period?
But we're still a repeating COLA giver, so I don't know if they would.
Yeah, well, that's for
told us that
retirees.
this year it
I'm
was
talking about
supposed
your
to
base
change.
salary for the employee.
Yeah, because
who's
we
a
have
30
2
year.
years that we're no longer.
Who's going to retire in 30 years? They're gonna project their salary from today, 30 years, and how much it's going to grow. So those variables are going to be changing all the time. But that's a drastic change, yeah.
Well, I mean, it affects all categories. So they have if somebody was hired at 45 and retired at 65, it's now 58% of the final salary, whereas before it was like 68%, 64%. So there's some pretty significant changes considering that. If somebody could find that out, I'd appreciate that.
I got it written, and that's my next email to the staff.
And again, as I always say when we talk about benefits, I think the court, even at the current plan assessment, I mean, before it was at 110%, which I just did think that's the only retirement plan that I know of where you make more in retirement than what you've actually made, but I think, 98% is retaining almost 100% of your salary, which doesn't include Social Security and other things, and I think that's something that. Because when I think you look at other retirement plans, the city, I think they max out at like 77%, something like that.
Commissioner, we might want to bring TCDRS back in because I'll tell you another thing that's going in my mind. Our average salary is about, I want to say it's about $48,000 to $50,000 is the average salary across everyone here at the county. And if it was 90%,
So how many people stay 30 years?
I'm sorry, 98% for average for retiree return. You would think that because they also give us the number.
It's after 30 years.
Oh, after 30 years,
Yeah.
right. Okay, so our retirees generally don't stay 30 years.
Right, they say 20.
Because, we were only paying about $27,000 average per year to our retirees. 28.
Which isn't that 58 to 60% number.
Yeah.
But it also has to do with the average age they come in, because coming in at 25 versus 35, your longevity and the long-term projections are
and we do have a younger workforce than average.
Yeah, well, and that's why on the the only one that they give here that has a 20-year example again for the current. So this is the most current plan assessment for us is someone hired at 45, they retired at 65, they retained 58% of their final salary, whereas previously, just in 2016, it was 64%, and I just don't understand the change.
I'm trying to find it right now. There was an email that came out where they made some kind of a plan design change, and I think that might be the missing piece here. But I'll have it.
Explain that change.
I'll get it and send it to the court before we take vote on it on the 27th. Just the court's. It's not going to change your rates, but it's a more informed decision.
Thank you.
All right.
Do we have TCDR scheduled to come back and present to the court?
No. We'll be bringing them in the spring.
And then also, I think to Commissioner, so if 90%, I think the court needs to vote on something, whatever our target is, or whatever we feel comfortable in doing that. Perhaps a future action for the court, or perhaps maybe it would be the same thing when we make this decision, is the court needs to decide what let's say it's 87%, 88%, 90%, whatever it ends up being, then what is it going to take for us to get there?
Right.
I think we need to know that.
They'll give us an estimate. Again, they're going to qualify it to the nth degree only because there's so many factors. But at least it gives us
the market.
But it'll at least give us a target that's attainable. Certainly more.
A goal to work towards.
Right. At least, yeah.
Absolutely. And that's a great idea. That's a great idea. Saying we want to get to 90. What's the rate that gets us there, and we can start playing the math. This rate's 8 years. This increases.
And should a court decide to decrease future benefits or increase the rates, that's a guide for the court. So if this court has decided 90% is the target, well then there's a variety of things you can do to achieve that 90%. And
the other
but
thing,
I think that's important.
If TC, one thing she emailed us during last budget cycle was, if we could identify for them what our goal is, like we'd like to be at 90%, and can you tell us if our goal is 5 years or 8 years, what that would be? She said if we could give her the goal and like how soon we'd like to be there, they could give us the rundown on both lump sum or percentage increases, how to do that. So if we want to, 90% is our goal. If 90% is something we'd like to shoot for, we could ask for that can you tell us in a 5-year and a 7-year plan or something like that?
Right.
What would be the difference?
Right. But the Commissioner is right about the guaranteed 7%. I mean, it is possible to have a down year, which would then increase the rate and could throw a wrench in the plan, but for the most part, we should be able to have a 10-year roadmap or something like that would, get us there.
Yes, sir.
And I think that's a very, I think actually that should probably be enshrined in policy, I think, so that way, if it's the will of the Commissioner's Court to attain, like I said, whether it's high 80s, 90s, whatever the court feels is, that really needs to be, I think, enshrined in policy.
Okay, so what we'll do is we'll ask for both a 5 and a 10-year plan, because, and I think if we get both 5 and 10-year, because they've told us we're already moving you towards fully funded. And so if we want to move quicker than their plan, maybe, and they're saying that it's generally taking about 13 years to get fully funded, it might not be as much as we think it would be to do a 5-year plan, but so we could at least ask.
And fully funded and 90% are two different numbers anyway.
True. So to get to a 90% funded ratio in 5 years and 10 years. What does that look like?
Yeah, I think I agree with I think that's a great idea.
Okay. Thank you.
Ready for the next item?
Yes.
Thank you. Item 5, discuss the staffing of the county's legislative work and the county's emergency operations work.
Okay, Judge, Commissioners, previously the court had, for the legislative work, the court had basically assigned that work to the county judge's chief of staff. And of course, we don't have that position filled currently. So I wanted to talk about how the court would like to staff that function. And then also, in speaking with Judge Vogt, we've been having these discussions for a long time about staffing the emergency operations work. And so just kind of wanted to have some dialogue with you all, what your thoughts are on it, what your preference is on how to do it. And I know, Judge Vogt, you have a lot of insight firsthand on this that I think you want to share with the court.
So I know previously the court had looked at hiring someone to be a legislative coordinator or director, and that fell through. We hired someone and then they didn't show up to work the first day. And so the court made the decision to go ahead and have me do the work for that state legislative session. Right after, as the state legislative session was wrapping up in May, we started to work on a federal legislative agenda that we had not brought to the court. Things have been in flux, obviously, and So I don't know if the court would like to look at having a staff member that already exists on the floor do this kind of work, or look to hiring someone to do that work for the court for a more long-term outlook. I do think that that person will have to kind of hit the ground running fairly soon in the new year, because we'll have to prepare for in 2018 for the 2019 state legislative session, but also start to look at how we address federal issues. I know that the court had previously wanted to try to have more of a presence and relationship with regional offices for federal agencies. And not only that, I know that we had also, we work with all of the local players, you know, the Chamber of Commerce, the CUC, NACO, EPCC, UTEP, so that individual has opportunity to build those relationships heading into the next state session, work on the federal issues. We've also talked about binational coordination, and that also seemed to fall through once we had the conversations with the Chamber and Borderplex, that this person might be able to pick that up also and work on those items as well. Personally, if I had to say what I thought would be ideal for the Commissioners Court long term, is to have somebody that works on these issues so that they are here for 10, hopefully 15, 20 years, and they build that rapport at the state with the legislators at the federal level, as opposed to someone working in a political office who, you know, the institutional knowledge lives and dies with an elected official. But that's just my perspective on the legislative piece, and I feel like we do have room to do a lot more. On the other side, when it comes to emergency operations, what we were doing in our office was starting to create plans around evacuating our courthouse. We are not experts at evacuating a building of this size or any of our buildings, but we were working on it, and we've actually come up with a plan that we've sent to OEM and the El Paso Fire Department, and work with our facilities manager, and we've created a team to come up with a plan that we think is good. Because quite frankly, given the state of things right now, it's scary to think that we don't have a proper plan in place and training in place to get our employees out of this building safely. If we had an active shooter, what do we do? And those are all things that we should be planning toward that we have not. Again, we have created an evacuation plan that's going through its process, but other things like the continuity of operations plans that we asked every department to work on, I think 3 or 4 years ago, our office worked with every department to create one. That should be updated annually. We had that flood that occurred in the DA's office recently. Had it been a much larger situation, they may not have been able to work out of that office, so where do they go? And so these plans are really important in terms of what we do as an organization to keep functioning. Every year in May or June, we bring to you the situation with fireworks. You know, what the outlook is, what the KVDI looks like, if we can do anything or if we can't do anything. Sandbags during rain. I know that we work with Public Works, but could we have a better streamlined process where we know there are going to be 5 designated sites every single year where sandbags are there and the residents can pick them up. And something that Betsy and I talked about is right now Wally, who is amazing, is at staffing the ESD meetings. And it would be maybe ideal to have somebody on board that could take on that responsibility to begin working with our ESDs in a closer capacity, to attend those meetings, to brief the Commissioners Court, to brief Betsy. And so, again, just 2 key positions that offer, I think, some really good work for the county. I just don't know how the court would like to proceed on handling that. They're both incredibly important, and it would be ideal to have somebody that was here for a more longer term. On the safety side of things, I did talk to OEM. Right now, they are not staffed to the point where they feel like they could come in and say, hey, El Paso County, we can create an evacuation plan for you. We'll work with all your department heads and the council of judges. They just don't have that capacity. They have designated someone to be like a county planner, but right now, for all intents and purposes, what he can offer is you create the plan, we'll test it and review it for you. And so we do need someone that is looking at all of these things. HR recently has been working with the El Paso Health, the city's health department, to designate the county as a pod, which is a closed point of dispensing. So in the event that we had a ricin situation or something where people had to get vaccines and medication quickly, county employees and their families would have a designated site, which right now is Escalete Park, to go to and get that medication dispensed. to them, and they're working on all those logistics. So we have all these disparate efforts, which are very good, and it's good for the county, but there's not one person who is the all-encompassing organizer, reports to somebody. And again, for that position as well, I would hate for it to be a position that lives and dies in a political office where, again, all that work's been done, say employee X leaves, who's gonna update the evacuation plan? Make sure that we have the same safety coordinators in place. Who's gonna operate the continuity of operations plan? Who's gonna be going to the Commissioner's Court to present on the fireworks issue? We can continue to do that for the next year while we're here, but I think that we need to start thinking longer term beyond the next 15 months. And really, if we're gonna think that far, then we probably need to have somebody start sooner than later, or have somebody in a different office start sooner than later. Sorry for that long-winded rant.
No, it's a good point, and something I've been thinking about for a long time. I was not uncomfortable with Judge Escobar and now Judge Vogt being overseeing that area, but every election brings new people and new staff and new things. And did we almost create a precedent where the judge makes those decisions, and what happens if there's difference of opinion among Commissioners Court about how this stuff is happening? So I agree. I think it needs to, though it's a political job, I think we need to take the political out of it as much as humanly possible, where it's not agenda-based or term-based based on, oh, I'm out of office? Well, we're burning everything we've worked on for the last 4 years. And those are, I agree with those situations, with those issues and concerns. My only fear is it's going to create a new job, and we're not very good about creating one job. They're going to need assistants and staff and office space and more assistants and assistants to the assistants. And that's my fear, is how fast departments can grow. And though I agree we need something, I think we need to find a way to make sure it doesn't become its own gigantic entity that is telling us how we govern.
And I think in both of these situations, they would be the collectors of information and gathering of information and taking it to the court for decision-making authority, whether it be approving the legislative agenda or, and for the safety piece of it, the county judge does, along with the mayor, have decision-making authority. But I think having someone that can help in making those decisions, and where the county judge is not necessarily the sole authority maker, for example, fireworks again. That goes to the judge can issue a declaration, but it goes right back to the Commissioner's Court and to the governor, and someone who can help organize all of that, sandbags, ESD work. So I do think that they could be full-time jobs in both of these situations. I don't necessarily know that it needs to come with like added staff and an office, and it could easily become that. I don't think it needs to. But at least to start having that conversation on what the court's desires are for these two important functions would be helpful, I think, for Betsy too, as she begins to plan for a more long-term vision for the county. Any thoughts?
I think as it pertains to the lobbying, we got to clearly delineate, I guess, what our contract is with our lobbyists. I think before we had switched over to the county judge, they were, I guess, they did make more visits with commissioners and sat down. And I know that there's a lot more planning that perhaps needs to go into having meetings to make sure, they can't do everything, obviously, particularly while in session. But we are paying full-time lobbyists pretty decent amount to do that and to provide reporting and to come and meet with us and to do those things. And I think we just, as we consider this, that also needs to be clearly defined as to what are our expectations of them when it comes to a lot of the coordination that goes into the preparation of the county's agenda.
And I agree, Commissioner.
Not just the document itself, but a lot of the meetings and things that you did. That's probably something that the lobbyists should be, to some extent, picking up a little bit. And
I think it would be ideal to have them here more often. I think when the employee didn't start and it was punted back to me, it was, I think, 5 or 6 months before session started. So we got into high gear just to get an agenda done. And then we hit session, and once session starts, they're really not available to travel as often. But I do think that they need to be here. I think the contract specifies 6 times a year, and anything beyond that, we would have to pay out of the county's pocket. But we could, and actually their contract is up for our consideration by the end of this year, by December of 2017, and we have the option for a 1-year renewal, at which point we'd have to negotiate or go out to bid, or but it would be ideal to have somebody over the next year to help us begin to think through the 2019 session. But we could also maybe amend that contract if we needed to clearly delineate where we think they might be able to do more over the next year heading into that session, you know.
Some of what, I mean, in that role, I think part of the critical internal role is during session, when there's request for things sometimes not even on our agenda other than in our guidelines, but somebody else brings it up and we're having to quickly analyze the impact of that. And it involves multiple departments, depending on, for example, if it's an elections related item, that person is basically the funnel following through with elections. Hey, how would this impact your operations? Do you see any problem with this? And kind of doing some of the internal shepherding of these issues. It's very, at that point in time, it's fast paced. It's really critical that we turn around and answer quickly, and that person is almost like an internal monitor to make sure that departments are aware of the issue. If they didn't see their email, they're calling them and saying, hey, I emailed you this, you need to look at it. It's critical that we get it turned back around. They need an answer by 4 o'clock this afternoon. Hey, is there any budget impacts to this? How do we care about this? So I think that's one of the values of the internal position, and whether that should be. I mean, that's basically one of the roles I don't think the lobbyists pick up, because they're asking us for like a 1-day turnaround, but somebody has to be on top of that.
And that's the thing, they do appreciate having one point of contact here that knows who to get the information from. But aside from that, we really have no federal presence, which is why I started to craft a federal agenda. The last time we had a federal agenda was probably, 3 years ago, when we had federal lobbyists, which we don't have any longer. We have started to rely on the National Association of Counties to help fill that gap, but they can only do so much as well.
And it's not as focused as you know, we may want to be.
Right. And so things come up. I mean, recently we had the tax debate and how that impacts the county and how it could impact our budget, and how it could impact our work around historical assets and not having the historical asset, the tax credit. And so, you know, I found myself in a bind. I was already in this role. Like, do I take it to the court? Should we take action on this? We need to have someone that is continually monitoring these developments, because at the federal level, it's not like a state legislative session there. It's continual and it's changing, and especially during this administration, we just don't know what might come up and for us to address. And so it'd be nice to have someone that has that knowledge, or gain that knowledge over time. But I don't know if the court thinks there's value in hiring someone outside of a political office, or if maybe in the time being we delegate this to another member of one of the offices. My only caveat with that is I think that during the state legislative session, I think that person, 90% of their time will be dedicated to that state legislative session. And so you essentially lose a staff member for that time. And if we want them to do federal work, then that's on top of that.
So one idea we discussed was, and I've had a couple conversations with some of you about the binational coordinator position. We've all discussed that there was not interest from Borderplex and the chamber. They're really
to house it in their organizations.
Right. And it wasn't even something they were real excited about being part of. They didn't really see the value to their organization. And that was after multiple meetings. But we talked about, I know the judge, prior judge reached out to Mayor Margot, and he didn't seem close to the idea of it being a shared position. But I will tell you, this is just the nature of shared work. Generally, where it's housed gets more attention. This is even true internally in the county. When you house something at a specific location, it gets more time and attention than the
offsite.
Right, than the offsite partner. And one thing we discussed is if we took the funding from the binational, created a governmental affairs person, and that position be both legislative and relationships with our with the county, with the city, with our smaller municipalities, just to help us with our Mexico counterparts, and did some of that work in the non-state legislative time, worked also on federal issues, that would possibly be a way to help fund a position and make sure that there's, even in off legislative time, they would also have an additional focus of working on those relationships with other governmental agencies.
And the federal agenda.
The federal agenda.
I just think that may be a little too much because there's really, I mean, to tell you the truth, there's really no off legislative time. I mean, some of the most important work that's done is right now in the interim for the, you know, when you're talking about the state legislature and the interim hearings that are going on. And, you know, I don't know if we've ever really been super active in that in the past, you know. I know we've always come up with a legislative agenda, but I don't know if we've ever been super active in the interim, which I think we need to be, because there are a lot of topics that they're discussing that our voices may not be, you know, not being heard when it comes to those. I mean, just because it's the interim doesn't mean that it stops. And really, to tell you the truth, a lot of times what goes on in the interim is much more important because that's when they're researching the issues. That's when they're actually, you know, deciding what bills and how they're going to be crafted and who they're going to affect and all that kind of thing. So, you know, I'm kind of worried about taking and doing the binational thing, like clumping that in together with the legislative stuff, because I think they're both important things. I think the binational position is something that we need, and I just don't see how you can have both.
Put enough focus on
one position doing both and having enough, you know, time to do both jobs. And I'm just talking about the state legislature, right? I mean, we're talking about doing federal stuff too, and I mean, that's year round.
And that became difficult because we wrapped up in May. I had started working on the federal agenda, went into a special session, put that on hold, then all this. So it is a lot of work. We do participate in the interim, and that's where the lobbyists play a really key role in that they attend hearings outside of El Paso, and we do submit interim charges for the House and Senate to consider on our behalf as items that we'd like for them to take up during the interim. Whether or not they decide those are important, you know, oftentimes some of them have been taken up, some have not. And when we've been asked to provide testimony, we do obviously send folks to do that, or submit written testimony, or but you know, could we definitely have a bigger presence? Absolutely, I think. And I think we have cultivated that El Paso County is very much engaged, and our state delegation appreciates that, but we could do more. You know, I had even considered, and I'll throw it out there, the chief of staff position, if we were to use that money to help fund, obviously, one or both of these positions, the legislative and the safety coordinator position. That's not enough for both. And it would potentially impact whoever wins the county judge race, and that they would lose that position.
But wasn't that position given back because it was being used for this?
I think perhaps.
Yeah. I think she gave up the chief of staff position. I wasn't here for it, but from what I understood, because I'd asked for a bunch of stuff. She gave up the position to create the lobbyist position, and then when that didn't happen, it went back to her, and that's where you took on that role. Because so it's kind of like taking it back away from the judge and giving it back to the position, correct? I don't want to do anything to take away from a future judge's position, but if that had already been done, given back because the role was used for the same thing, I'm fine with taking it back away and making it that role.
I don't know if that's necessarily why the change was made. I don't really remember off the top of my head either, but I do think that that office had taken on these two big responsibilities, and that's just the way that it, we just took it on and ran with it, and that was what we did. But I'm trying to find a way for us to fund these two critical positions without impacting our budget or having to dip into the general fund and looking for existing positions that haven't been filled. That was one of them. The binational coordinator was another. I mean, I don't know if the community IDs is. I was literally just looking, not that we shouldn't fund that at all. I just don't know. I'm trying to find areas of funding if that's the way the court wants to go.
Let me ask you a question. How much of your chief of staff time was spent on legislative stuff?
During session, probably about 95% of the time. Could it have been all the time? Yes. But that's what we were lacking on the federal side. Because when I wasn't doing the state side and not doing the office stuff, then we were trying to fill in the gap of the federal legislative agenda, which we've come up with a draft, but things have changed since we've come up with that draft. We haven't even taken it forward.
Let me try to change the way I'm asking the question. If the judge is not responsible for, your experience in the judge's office and now being the judge is not responsible for the lobbyist stuff, is there a need, legislative stuff, is there a need for the chief of staff position? There's always a need for position if you look.
Yeah.
What I'm trying to do is, I don't want to cheat any future person out of the position, but from how it was explained to me when I got elected, is the position had been given up to create the lobbyist position. The lobbyist position didn't happen, so it was given back, and that's where it came in. And if that's the case and we're taking it back again, I've got no problem taking it back. But I don't want to cheat someone out of a position if it's needed, but I don't want to give someone a position that's not needed also. So
I would like to add on that, Judge and Commissioners, what you all have done that might help a future person taking that position is you've created more flexibility in the staffing of your offices. So there would be flexibility for an incoming candidate or an incoming judge to look at those two positions that would remain and adjust them within the guidelines you all have set up to make sure their needs are met.
But I see what your question is. Yeah. Is that third person necessary if these are taken away?
If those are taken away, or right now, let's worry about the one the legislative is taken away. Will that hamper the future person coming in as judge?
It all, and that's where it gets hard. It depends on the position. You all know that every office is different and
how they want to run their
work, and they want to run their office. So I wouldn't know. Could they do with two? Maybe. Could there be a need for a third? Maybe. I was thinking selfishly probably for the more immediate term, and since that is sitting there vacant, and I don't intend to hire someone for 15 months when a brand new person is going to come in and try to learn something and then they have no job after the 15 months. I don't think it'd be fair for the county, and I don't think it'd be fair for an individual, so I thought that would be a good use of that money. But I do have, some concern that it could hurt an incoming county judge with not having that third position. But, we could also just fund this through other means. But I don't know where we would pull that money from.
Based on what I understood of how it worked, I've got no problem with taking that position and using it for that position and using it for the legislative position.
And it would not be housed in the county judge's office. It would be a position that the court could decide who it reports to, whether it would be Betsy. Maybe
this is the best way. That way it keeps it non-political.
Right. It's neutral. They are the feeders of information to the commissioner's court. We make the decisions on how they should move forward. Same thing for the safety coordinator. I think right now Melissa Carrillo, our HR director, is listed in her job description as the safety coordinator for the county, which is a bit unfair. Or is that
No, that's not the same thing.
Okay.
That's internal. That's internal. No, she's listed as the ADA coordinator. And now we actually have a position for that.
Okay, I thought she was listed as safety internally.
Like, this is like employee safety, like car accidents.
Ah, okay. So whether that, you know, that position could be under Betsy as well. And so,
You know, Judge, maybe with, I agree, I think with what you're telling us today, and with the thought of a future judge possibly wanting that position back, that we put a caveat that we send that position under administration, and but the possibility of another. Are we talking about another position over with a judge, or are we talking about possibly bringing that one back?
So how long? I mean, I'm confused because I thought it was a different position that the judge gave up, and not the chief of staff position, because you've been her chief of staff since she's been a judge, right?
There was a lot of flux, and so there were 4 employees. It was the judge and 4 employees.
Right.
The judge gave up 1 employee to work under the chief administrator's office, which was Lorena Rodriguez, to help offset the cost of getting that office started. So we lost 1 member at that point. It was down to 3. We then, the chief of staff was never on the table. That was the position held by previous county judges that we just never filled. And so it also came at a cost savings to that office and to the county. When added responsibility was given to the office, I think that's when we bumped up. And I was not chief of staff the entire time the judge was county judge. I was the policy and programs coordinator at one point, which is commissioner, and then public policy director, and then bumped up to chief of staff. And took on all these other responsibilities. And so
I mean, but before the chief of staff position was created and you're put in that position, you guys had 3 staff, right? And there was enough work for 3 staff, right?
There was enough work, and we have enough work now. Celeste and Nicole have very graciously agreed to pick up the volume of work that we have to do, because it's only for 15 months. And so we just know that we're going to plug forward knowing that there's going to be an increased amount of workload. And I think taking these 2 would be helpful. Right now, Nicole has been very helpful in creating the emergency evacuation plan. Again, we are not planners. We've been working with the experts, but it's a little scary when you're preparing a plan for our entire organization. And right now it's only the courthouse. We haven't even looked at our annexes or the MDR building, which we need to. And the continuity of operations plans are 3 years old now. It's time to revamp those. And so it's just having the capacity to do all of that on top of everything else that becomes difficult. So taking this from the county judge's office would be helpful. Will a future county judge need that 3rd position? Maybe, but at that point they may want to come back to the court and ask for that funding. But for the time being, over the next 15 months, I'm happy to get someone on board so that we are best prepared for the 2019 legislative session, the federal issues that are going on, and for someone to start getting a grasp on the safety issues that we need to address for the county. But again, we wouldn't have all of the funding available. That even if we were to take the funding from that position, we would still lack another, I don't know, 70,000, something like that. So we'd have to figure out where we get that money from. But it sounds like the court has an interest in seeing these 2 positions be standalone and potentially under the chief administrator's office. Please correct me if I'm wrong, though. I don't want to assume anything.
I mean, I think certainly the emergency management component. I mean, I don't know if you have any thoughts on that. That certainly I think has to fall under operations, because that's inherently an operations thing.
I would, the emergency operations definitely all year long, and it's not an offense to the way we've been doing it by any means, but depending on what the emergency is and the coordination, it is generally happening either through my office right now. Like your office has been doing the planning piece of it, but it's happening all the time. And the other part that Judge Vogt mentioned, and that I think is critical, I say this all the time with our boards. I mean, we have boards like the ESDs that we don't have the internal expertise to really be good staff liaisons. And that's not an offense to Wally either. He's a great budget liaison to them, and I think they've made major strides in those areas. However, having an emergency operations person who could be that liaison with ESDs and understand and speak the same language and know what is logical planning, it's a different expertise versus budgeting. And having someone internal to help more on emergency operations, like in preparation for flooding. That's not even a public works expertise. For example, telling people turn around, don't drown. I mean, that's more of an emergency management coordination piece. Knowing that we need to get this information out to our outlying unincorporated areas or smaller communities. We need to coordinate, even mapping where we have sandbags. What's the distance from various populated areas to get to sandbags? And that's something that's constant, year-round and operational. And like at 2 in the morning or 4 in the morning when it's flooding, having that point of contact just to even be a resource officer, to say, hey, we need these resources from these places to work with our departments, would be very, very useful.
Even during freezes, I mean, we'd be up at 3 a.m. knowing that it was freezing on our bridges and on our roads, and we would have to figure out a way to coordinate getting the message out to the media, to employees. We now have subscribed to the Everbridge system, which is a process we've been working on for the last 2 years to make sure all of our employees are in this database where they can get a text message and a phone call and leave a message, and we can track who's reading these and getting and answering the phone. We've done a lot of work to get to this point, but it's maintaining that work in the long term that will be really important for the county. Commissioner, do you have any thoughts on the legislative piece and it being under?
On the legislative side, I mean, that's, I view that more as a court policy matter. You know, the Commissioner's Court, I think as a body, should be driving the agenda, you know, and I think that's always been an issue because there's, you know, I mean, it's just the nature of county government where we have the various departments who are independently elected throughout county government, but it's ultimately the Commissioner's Court that sets the policy agenda, and others may disagree with that, and you know, I think they have to go their own avenues if they want something, but I view that as a Commissioner's Court policy position, sort of. How that's organized, I don't know. You know, I know at the city, I know that somebody in the county attorney, in the city attorney's office handles their legislation and does that, and having the legal background certainly I think helps. You know, so I don't know if that's something that the court wants to consider. But then, you know, we're unique from the city in the sense that we have those unique coordination issues where we do have to collaborate with all these independently elected officials to make sure that, you know, and even though at times we may be at odds, nonetheless, it's still advantageous to have those meetings. And so I can see a position kind of being, you know, under Betsy that can probably perhaps best facilitate that.
And in reality, the majority of times, it is in the best interest of the county. The coordination piece. There are those times when we do have to, and sometimes it's a difference between one elected official and another. That's often the case too.
And I mean, any given year we'll get like 60 to 70 concepts to consider for the next legislative session, and that's from all of the departments and elected officials, and it's weeding that list down to tangible proposals, taking them to the court. You know, they'll propose something at one point and then turn around and say, no, like, never mind, we figured it out internally and administratively. And so I do think that coordination with departments and elected officials, it helps to be under the chief administrator's office. Oftentimes I felt like I had 5 bosses. I often said that because I wanted to make sure that every commissioner felt like their agenda was being pushed forward. And so I think that person will feel that as well. But they would at least have the benefit of having the chief administrator as a sounding board, and but that's my personal how I felt. I wanted to try to make sure everybody felt
Can I give you an example of why, just on that exact note, and I don't know that you ever ran into this when you were in the chief of staff position, but one challenge you can run into is, say for example, there was a legislative policy or proposal on the table, and your elected official that you did work for did not agree with it. And I know there were a couple times where there was something where, for example, another elected official,
bring things up.
right, or somebody wanted to bring something up, and it was very difficult. It can be difficult for the person if you work for a member of the court who opposes it and would prefer it not be brought up.
But you still have to do due diligence.
But you still have to bring it up.
Have that knowledge.
And it can create a challenging situation for the person who's in that role.
And I think that's the unique nature of.
Ruben's telling us he really wanted fireworks all this time.
Start that conversation.
Yeah, I mean, I think that's the unique nature of policymaking. Is that I mean, as sometimes during the formation process, I mean, it's that's why even under the Public Information Act, I mean, we're allowed to keep things under policy draft because there's times where there's ideas that are still being worked on that aren't necessarily ready for public consumption because they're just ideas. You could be scrapped, but I don't know. I mean, I think it's clear. I think from a funding perspective, I think there's a general. I mean, it seems like there's general agreement that I don't know if it's going to cover. And so, I mean, something else I was going to bring up on that point. I don't know if there's someone from the sheriff's department that could be dedicated to
the emergency,
because they also often are called first as well. So I don't know how.
Judge Vogt and I just talked about that this week because there is a person from the sheriff's office we've worked with in the past and who has also been assigned to the emergency management. I think they housed out of the emergency management office.
It's a deputy audit, and there was another individual, and both of them were assigned to the emergency management unit. And so they had an office at emergency management. They were there often. And we have worked with them to create this evacuation plan, and they're very helpful.
They don't help on the flood response and sandbags, but we could definitely ask if that's a possibility. That would they be willing to broaden that and designate
maybe one person
to work with us more closely.
Yeah, because if there's already somebody if they're already in the Office of Emergency Management, so they're doing the planning aspect, I mean, and then a lot of it, the other, I mean, once that's in place, and a lot of it is just operational and execution, when I'm like, hey Betsy, there's flooding, and is there just sandbag ready, or
Right.
I don't know. I don't want to create it. That's the thing. You don't want to create duplication of.
Right. And so we did consider that too. We can talk to the sheriff and see if he would be open to having an individual take on a larger role. They are still deputies, so he still is out on the field and doing his regular daily duties. But if they could try to alleviate that a little more to help with this. What I'm thinking is that maybe we go back, we maybe draft 2 job descriptions if we don't already have them, and look at speaking with the sheriff as to whether or not somebody on his team could help fulfill some of the work under the safety coordinator position. And the legislative piece drafted the job description as well. We'll also look for funding for both positions or just one, depending on the conversation with the sheriff, and then come back to the commissioner's court with what we've discovered. But now that we know that the court is in favor of potentially looking at the importance of this and looking at a standalone position for legislative piece, and then we'll still work out the safety coordination.
So we'll bring it back
to see some hard numbers.
Yes, sir. Yes, sir. We will bring it back. Okay. Thank you.
Thank you for the direction.
Our addendum, item 7, pursuant to the Texas Local Government Code, section 115.021, audit and settle all accounts against the county shown on the attached listing and direct the payment of those accounts.
One thing I'd like to point out is one item on the pay claims is on the county civ loan. That money came in last Tuesday. We set up the account with INB, and we've already secured a cashier's check from that account with a check payable to Texas Department of Transportation. It's on the paid claim so that we can release that so that that project can get underway and the county will have completed its matching funds. So that's the major item that I had on for today. But all the other paid claims because of the canceling of Monday meeting are on for today. Attorney payments, travel, everything that we could get on, we did get on.
And I mean, we ended up having to have a special session meeting on Monday, and I apologize for that. I thought that we were in the clear, but the UTEP issue came up, which was something we did not count on. We didn't know that that was even an opportunity. So if there is any other claim item, I mean, Monday is still a viable option, but it sounds like we're pretty much covered, I think.
Thank you.
Could we have a motion to approve, please?
Move to approve.
Second.
Commissioner Pettis?
Aye.
Commissioner Leon?
Aye.
Commissioner Stout?
Aye.
Commissioner Haggerty?
Aye.
Let's vote.
Aye.
Motion carries. That completes today's agenda. The meeting is adjourned at 12:15 p.m.